Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond.
Eveniment cărora le mulțumim. Foarte important sunt de asemenea speakerii într-un eveniment și le mulțumesc tuturor pentru implicare și o să începem cu un panel dinamic în care vom discuta despre fiscalitate alături de 3 experți, după care îl vom avea alături de noi pe Ministrul Finanțelor. Deci rămâneți online împreună cu noi în următoarele ore. V-am pregătit multe surprize, vom avea alături de noi 2 miniștri și vom aborda subiectele propuse în agenda noastră. Îi salut pe invitații primului panel, 3 speakeri specialiști în domeniile lor de activitate, Teodor, Gabriel, Andrei. Avem mult conținut de calitate pentru audiența noastră. Înainte de a intra în prezentarea fiecăruia dintre voi, aș vrea să ne spuneți foarte pe scurt ce e relevant astăzi din perspectiva fiscalității în opinia voastră. Primul panel este despre fiscalitate. În 3 sferturi de oră, Ministrul Finanțelor va fi alături de noi. Rămâneți online și urmăriți-ne. Dragilor, haideți să vedem ce e important din perspectiva fiscalității. Teodor.
Dacă e să ne raportăm, bună ziua în primul rând tuturor. Îmi pare bine să fiu aici în acest eveniment. Dacă e să ne raportăm strict la temele de interes din acest moment, aș spune că principalele 2 lucruri și coordonate importante pentru fiscalitatea din România sunt, pe de o parte, digitalizarea și, în al doilea rând, reforma administrației fiscale, relația cu contribuabilul și nu numai, îmbunătățirea colectării. Astea aș spune că sunt problemele cele mai fierbinți în acest moment. Desigur, de aici rezultă o serie întreagă de alte teme și subteme pe care probabil că le vom atinge chiar și marginal în timpul prezentării de astăzi.
Gabriel Tănase.
Bună ziua tuturor! Mă bucur să fiu alături de voi astăzi. Eu vin dintr-o zonă mai tehnică și aș insista în zona de digitalizare. Cred că e un subiect care arde și trebuie făcut ca la carte, transparent, și o să discutăm probabil mai târziu ce înseamnă această transparență și cum putem să educăm oamenii să adopte cât mai mult canalele alternative în această zonă. Mulțumesc.
Andrei, ce e important în opinia ta în pregătirea evenimentului? Am văzut în conținutul prezentării tale un cuvânt cheie care se repetă: complexitate.
Da, cred că dacă urmărim reglementările europene, dar și cele din Statele Unite și jurisprudența Curții de Justiție a Uniunii Europene, ar trebui să observăm, chiar dacă nu e o chestiune arzătoare, că sub umbrela unui principiu al dreptului Uniunii Europene, principiul solidarității sociale, pare că se manifestă tendința de a se trece de la o impozitare proporțională cu câștigul întreprinzătorului la o impozitare proporțională cu alte valori numerice, cum ar fi cifra de afaceri, numărul de copii, asupra afacerii, tipul activității economice și, în general, nivel de conformare cu valori non-economice, dar care sunt importante pentru societate. În acest context o să discut și astăzi despre importanța complexității în dreptul social, care nu reprezintă un subiect de controversă, complexitatea. Se știe că fiscalitatea e ceva complex.
Andrei Săvescu, fondator juridice.ro, îți mulțumim și în câteva zeci de minute vom intra în detaliu în ceea ce privește subiectul tău. Teodor Artenie, industria de e-commerce anul trecut a crescut spectaculos și în 2021 vedem o cadență de creștere interesantă atât pentru jucători cât și pentru investitori. Hai să vedem din perspectiva fiscalității ce e important pentru e-commerce. De asemenea, tot domeniul acesta care ține de tehnologie, ce este relevant să le explicăm celor care sunt astăzi alături de noi, temele tale de interes pe care le-am pregătit pentru audiență.
Mulțumesc, Claudiu. Aș adăuga chiar la ce ai spus tu. Într-adevăr, comerțul online a cunoscut o creștere spectaculoasă și probabil că și în 2021 această tendință se va păstra. Dacă ne uităm la statistici, am spune că România încă nu este acolo unde ar putea să fie. Datele statistice publicate de Eurostat arată că afacerile din România au o pondere de cam 12% în 2020 de vânzări e-commerce, care includ și vânzările online, față de media, să-i spunem, celorlalte state, care este undeva la 20%. Aș spune că este de bun augur, există potențial. Prezentarea mea, deși este o prezentare pe teme fiscale, vine cumva să prezinte o posibilă sau posibile oportunități pe care noile măsuri de TVA anunțate la nivel comunitar le pot genera pentru afacerile din România. Pe scurt, ce se întâmplă? În momentul de față, cel mai probabil, comercianții din România au un grad de penetrare destul de redus pe piețele din celelalte state membre. Nu o să fac acum o teorie a motivelor pentru care această penetrare este redusă, ci mai degrabă m-aș referi la un motiv pe care eu îl consider relevant și anume acela fiscal. În momentul de față, dacă vrem să vindem online din România în Bulgaria, în Ungaria, în Grecia, în oriunde în Uniunea Europeană, avem un impediment de ordin administrativ și fiscal. Și anume, de fiecare dată când ne gândim să ne extindem și pe alte piețe, ne lovim de obstacolul TVA. Ce înseamnă asta concret? Înseamnă că în momentul în care eu ajung să vând către consumatori din alte state membre, trebuie să-mi verific și să monitorizez foarte atent vânzările pe care le fac, astfel încât să mă asigur că nu cumva trebuie să mă înregistrez fiscal în toate țările în care am consumatori. În momentul de față și până la 30 iunie, când măsurile existente vor fi înlocuite de pachetul nou, există niște plafoane de vânzări la distanță, astfel încât vânzările către consumatori peste 35.000 de euro sau peste 100.000 de euro în alte țări mă obligă pe mine, comerciant, să mă înregistrez fiscal acolo. Desigur, a avea înregistrări fiscale în mai multe țări este o problemă administrativă destul de serioasă, pentru că mă costă să am contabil, să depun declarații, să am relații cu autoritățile fiscale de acolo, să fiu verificat, controlat, etc. Astfel că multă lume spune pas. E prea complicat, nu vreau să-mi bat capul. Ca o mică paranteză, nu știu de câte ori ați intrat pe site-uri mari de comerț din ăsta online, o să dau numele Amazon că este cel mai mare, să vedeți că anumiți comercianți nu vând în România. Nu cred că este din rațiuni logistice, pentru că transportul nu este acum așa o problemă de organizat, mai ales prin serviciile oferite de Amazon. Mulți comercianți nu vând în anumite țări tocmai din cauza acestor restricții privind vânzările la distanță. Nu vor să se înregistreze fiscal și în alte țări unde au probabil un volum mic. Ei bine, din punctul de vedere al comerciantului român, care încet, încet începe să descopere canalul online și să vadă potențialul acestei piețe virtuale imense, problema asta cu înregistratul în alte țări poate să fie un factor de descurajare destul de puternic. Ce se întâmplă de la 1 iulie 2021, când intră în vigoare pachetul nou de TVA? Nu va mai fi o problemă. Nu vom mai avea nevoie să ne registrăm în 20 și câte state membre sunt acum, după ce a ieșit și Marea Britanie din Uniune. Vom avea posibilitatea să vindem direct din România bunuri. Nu va mai trebui să ne registrăm, după cum spuneam. Vom putea colecta TVA din România, dar aplicând cota de TVA din statul membru al consumatorului. Astfel că va trebui să știm unde pleacă bunul, să știm datele consumatorului, să știm valoarea vânzării, să știm cota de TVA aplicabilă în statul respectiv, astfel că la sfârșitul unei perioade de raportare noi vom face un decont special în care vom scrie: am vândut 100 de lei în Bulgaria, am vândut 500 de lei în Ungaria, am vândut și așa mai departe. Acest decont se depune la organul fiscal din România, ANAF, TVA se raportează și se plătește integral în România, urmând ca apoi statul român să se deconteze cu statele membre unde am eu consumatori. Poate părea complicat la început, dar pe măsură ce lucrurile își vor intra într-un anumit ritm, mă gândesc că lumea va percepe această schimbare ca pe o imensă oportunitate. Ăsta este de fapt și mesajul pe care vreau să-l transmit. Sigur, poate sună simplu. Nu e chiar simplu. Este nevoie de infrastructură pentru a putea funcționa în regimul ăsta. Există un sistem la nivelul Uniunii Europene care este disponibil și în România, se cheamă sistemul One Stop Shop. Până acum s-a chemat Mini One Stop Shop pentru că era limitat pentru anumite tipuri de prestări de servicii, dar de acum acest sistem se va extinde și va putea fi folosit și pentru livrări de bunuri. One Stop Shop ce presupune? Este un portal pe care îl accesezi, te înregistrezi și practic primești dreptul de a face asemenea vânzări. Din informațiile pe care le am, acest portal este funcțional, desigur nu poate fi folosit pentru că încă nu au intrat în vigoare prevederile relevante, dar portalul în sine este funcțional și va fi deschis de la 1 iulie, va putea fi folosit de cei care doresc să o facă. În momentul de față, ca proces legislativ pe tema asta, avem proiectul de lege, s-a discutat în Comisia de Dialog Social, este o ordonanță de urgență care ar trebui să fie promovată, dacă n-a fost deja publicată în monitor oficial, îmi cer scuze, urmând ca în perioada următoare să se publice și legislația secundară care să ne permită practic să ne folosim de aceste noi reguli. Un alt punct important în cadrul acestor modificări este cel al platformelor electronice. Comercianții sunt o categorie de persoane afectate în mod pozitiv, aș zice, de aceste schimbări. Mai este și cazul platformelor electronice, aceste așa numitele online marketplace, gen Amazon, după cum spuneam, Memag, Evomag și alții ca ei, care vor căpăta un rol nou, un pic mai complex din punct de vedere fiscal. În anumite situații, interfețele, așa sunt denumite ele în legislația europeană și în legislația națională care urmează să se publice, interfețele electronice vor avea un rol destul de important pentru că vor fi folosite de autoritățile fiscale ca instrument de control. Sigur, este o parafrazez acum și am tras o concluzie citind niște texte destul de complicate din punct de vedere tehnic, legislativ. În anumite situații, interfețele electronice vor ajunge să cumpere și să revândă anumite bunuri către consumatori. În ce situații? În situațiile în care, de exemplu, vânzătorii, furnizorii bunurilor respective sunt din afara Uniunii Europene. Vorbeam la începutul prezentării despre digitalizare. Sigur, digitalizarea se va întâmpla și digitalizarea este esențială pentru ca acest mecanism să funcționeze. Mai vorbeam și despre îmbunătățirea colectării. Acest pachet are un obiectiv secundar, pe lângă simplificarea comerțului intracomunitar. Un alt obiectiv este acela de a capta mai bine fluxurile de bunuri din Uniunea Europeană, acele fluxuri care în momentul de față nu sunt suficient de bine supravegheate, urmărite și impozitate. Un asemenea caz este cel al furnizorilor în afara Uniunii Europene care vând bunuri prin platforme online. Sigur, vi s-a întâmplat să cumpărați diverse obiecte de mică valoare de pe anumite site-uri, de pe anumite magazine online, ca să aflați ulterior că bunurile vin din Statele Unite, din China sau din alte părți. Ei bine, de multe ori aceste fluxuri nu erau suficient de bine impozitate, așa că prin acest pachet de măsuri se dorește o mai bună impunere a acestor tranzacții. Interfețele practic capătă un rol foarte important, pentru că în cazul acesta specific și în altele, interfețele se va considera că au cumpărat bunurile și le-au revândut, astfel încât revânzarea să fie tot timpul impozitată în Uniunea Europeană, să nu existe modalități prin care această tranzacție să nu fie taxată cu TVA, evident. Sigur, asta va presupune anumite schimbări pentru platformele electronice, schimbări destul de, nu le-aș spune importante, dar mai ales în zona operațională, schimbări, le-aș numi schimbări, n-aș vrea să folosesc cuvinte mari, pentru că nu vreau să creez impresia că sunt niște lucruri foarte complicate de realizat. În realitate mă aștept că din punct de vedere operațional aceste platforme au deja mecanismele de urmărire, de cunoașterea clientelei, de cunoașterea furnizorilor, au implementate tot felul de politici foarte riguroase de control, astfel că noua modificare fiscală n-ar trebui să vină cu un impact și cu un șoc foarte mare asupra lor. Sigur, reversul este că aceste platforme vor avea obligații fiscale noi și vor răspunde fiscal, mai mult decât o făceau până acum, pentru anumite fluxuri de bunuri. Tot rău spre bine, aș spune. Mi se pare importantă și binevenită schimbarea aceasta.
Teodor, noi suntem cu ochii pe prezentarea ta,
Da.
să ne spui tu, te rog, când să trecem la următorul slide, să audă și colegii din emisie.
Se poate merge pe următorul slide, sigur. Și următorul. Bun. Un alt aspect important, apropo de interfețele electronice, este că și acestea vor putea aplica noile reguli privind vânzarea la distanță. Deși întrucât ele vor fi asimilate unor comercianți în anumite situații, vor putea aplica la rândul lor regimul despre care vă spuneam, one-stop shop-ul, disponibil în general comercianților care vând prin resurse proprii, prin site-uri proprii. Putem merge și la următorul slide. Și încă un slide. Mulțumesc, e foarte bine. Spuneam de asemenea de faptul că noile măsuri noul pachet legislativ are ca scop o mai bună captare a fluxurilor intracomunitare. Se întâmplă în momentul acesta ca anumiți comercianți din afara Uniunii Europene să importe bunuri de mică valoare în Uniunea Europeană, să le vândă către consumatori și tranzacții care rămân neimpozitate. De ce? Pentru că în momentul de față există un plafon pentru importuri. În România este de 10 euro, importul de mică valoare, aceste BMW-uri. Și importul, evident, nu se impozitează cu TVA, urmând ca vânzarea să se impoziteze sau nu, în funcție de cât de compliant este respectivul furnizor. De cele mai multe ori se întâmplă să nu fie impozitată. Și în urma unor studii s-a ajuns la concluzia că există niște pierderi de venituri destul de semnificative, astfel încât pachetul ăsta despre care vă tot povestesc a venit cu o măsură suplimentară în cazul importurilor de bunuri de mică valoare. Astfel că de la 1 iulie 2021, importul bunurilor de mică valoare, de data aceasta valoarea crește de la 150 de euro, va fi de asemenea scutit de TVA, urmând ca vânzarea ulterioară să fie impozitată la consumator, în orice situație. Se vor implementa niște controale suplimentare în vamă, astfel încât pentru a putea scuti importul de
And the first ad that online was just blinking and showing to essentially anyone who is out there.
L-am pierdut pe Teodor, cu siguranță dintr-o eroare tehnică. Un invitat special din panelul următor s-a conectat și este alături de noi, înlocuindu-l practic pe Teodor. Ține foarte mult de platforma pe care suntem acum. Hai să mergem mai departe, vom discuta despre cyber security, despre fiscalitate, despre digitalizare și cyber security. Gabriel Tănase, KPMG, hai să vedem ce e important din perspectiva aceasta a digitalizării pe zona de fiscalitate. În opinia ta, și cum putem analiza riscurile acestea financiare și le putem corela cu riscurile cyber?
Mulțumesc. Cred că principalul beneficiu în momentul acesta pentru digitalizare în zona fiscală e transparența. Practic, toate tranzacțiile care se întâmplă prin platforme electronice sunt mult mai trasabile și mult mai ușor de urmărit și până la urmă de impozitat, acolo unde e cazul, decât o tranzacție care se desfășoară printr-un canal clasic. E clar că obiectivul e ca numărul tranzacțiilor să fie cât mai mare, să fie o adopție pe scară largă. Și aici sunt o serie de pași făcuți atât la nivel european cât și la nivel local. O să dau doar câteva exemple. Există directiva NIS, unde platformele de e-commerce sunt considerate platforme critice și trec prin niște verificări de securitate și sunt obligate să implementeze o serie de măsuri de securitate pentru a minimiza riscurile din punct de vedere acces neautorizat, atât la informații cât și la resursele financiare care se tranzacționează aici. Există chiar o inițiativă, citeam zilele trecute, în Senat a trecut o lege și urmează să fie adoptată în final Camera Deputaților, apoi promulgare, prin care cei care făceau tranzacții neautorizate în numele altor persoane, prin canale electronice, să fie pedepsiți mult mai drastic. Deci, practic, se implementează o serie de măsuri pentru a crește încrederea oamenilor în astfel de platforme și când zic oameni sau populații și când zic oameni nu mă refer doar la consumatori, ci și la cei care dețin business-uri și care pot merge către platforme electronice să vândă prin aceste platforme. Cred că e foarte importantă această încredere și ceea ce facem pentru a crește încrederea să fie cât mai bine mediatizat. De ce? Pentru că, citeam chiar iarăși acum ceva vreme, în România cei mai mulți posesori de smartphone, de exemplu, foloseau dispozitivele pentru a accesa rețele sociale, Facebook și alte rețele. Și e-commerce-ul venea și el undeva în top, dar diferența între între aceste rețele accesate, da, și tranzacțiile de e-commerce era una semnificativă din punct de vedere număr utilizatori. Cred că oamenii încă nu percep suficient și nu sunt educați suficient să folosească aceste platforme de e-commerce care, mai ales într-o perioadă ca aceasta de pandemie, pot să le aducă beneficii clare, asta pe termen scurt și, bineînțeles, pe termen lung. Ce ar trebui făcut? Ar trebui făcut mult mai multă mediatizare și în special la elementele bune, la elementele care fac educație, să spun, pozitivă. De ce? Toate evenimentele negative, acces neautorizat, hacking, imediat au acel element de spectacol și sunt preluate de canalele media, de televiziuni, de site-uri de știri și sunt prezentate. Vai, ce s-a întâmplat. Da, asta e realitatea. Din acest motiv sunt implementate toate aceste măsuri de securitate, inclusiv la nivelul acestor platforme electronice, dar cred că educația în zona persoanelor fizice, a consumatorilor, e foarte importantă și asta se face nu doar prin explicarea beneficiilor, ci și prin modele de succes bine prezentate și pe toate canalele posibile. Revenind la riscuri, e clar că riscuri sunt și mai ales atunci când nu avem poate o educație foarte bună. Și o să dau iarăși exemple recente din România, mai multe cazuri în care companii au fost afectate de diverse atacuri cibernetice. Știu de cazuri în care au dat click pe un anumit link sau dintr-un e-mail sau au accesat anumite fișiere transmise pe e-mail și s-au ales cu fișierele criptate. Iar acest lucru a mers până la momentul în care activitatea operațională a unor companii care aveau inclusiv o prezență online semnificativă a fost blocată. Știu cazuri în care prin astfel de mesaje au fost acel numit business email fraud, au fost inițiate tranzacții în conturi de unde s-au putut recupera foarte greu banii parțial sau chiar deloc. E foarte importantă această educație, cum spuneam. Iar riscurile, dacă la început par a fi unele tehnice, foarte, foarte ușor ajung în zona financiară. Și aici sunt le-aș privi din două aspecte. E clar că sunt riscuri care vin din pierderi directe în urma unor astfel de atacuri și pot fi și riscuri care vin din zona de neconformitate, de data aceasta pentru comercianți sau pentru platforme, unde în cazul în care au obligativitatea să implementeze control de securitate și nu o fac, ei vor fi supuși unor verificări, fie direct de către anumite autorități sau prin intermediul unui proces de acreditare, certificare, să poată avea un risc de amenzi care ajung până la un anumit procent din cifra de afaceri, chiar între 2 și 5%. Deci discutăm despre niște cifre semnificative în această zonă. Cred că sunt deja pași importanți făcuți în piața din România și, glumind puțin, această pandemie a ajutat la acest proces de digitalizare. Era o glumă pe rețele sociale în care spunea cine a accelerat procesul de digitalizare, CEO, departamentul tehnic sau COVID. Da. Din păcate a fost nevoie poate și de un astfel de imbold, însă ce s-a început trebuie să continue și cred că e foarte important și în zona entităților statului să continue acest proces. Am văzut o creștere semnificativă de tranzacții și de plăți prin ghișeul.ro, prin comparație cu anii trecuți. Și de asemenea am văzut o abordare de transparență acolo. A fost în ultima perioadă, știu că un specialist a găsit, de exemplu, o vulnerabilitate în ghișeul.ro, a fost abordată etic și CERTA imediat a rezolvat-o. Deci sunt pașii corespunzători făcuți în direcția care trebuie, doar că trebuie să-i combinăm și să fim siguri că îi comunicăm foarte bine și creștem încrederea în astfel de platforme. beneficiul va fi clar atât de partea consumatorilor, cât și de partea comercianților, cât și de partea entităților statale, da? Pentru că, exact cum spuneam la început, e mult mai ușor de urmărit tranzacții într-un astfel de mediu electronic. Pentru
L-avem
moment
alături de
avem
noi
Mașo
din nou
aici.
și pe Teodor, îl salutăm și o să îl întreb ca o concluzie prin care Teodor, poți să continui cu prezentarea ta în contextul acestor schimbări fiscale în comerțul online de la 1 iulie. Vom vedea practic această transpunere a directivei europene. Sunt firmele de la noi pregătite, atât platformele mari de marketplace, cât și magazinele online, de talie medie, să spunem, talie medie și mare?
Aș zice că e greu să fii pregătit în acest moment. Cred că putem merge chiar pe penultimul slide, cu concluziile. Este greu să fii pregătit pentru că pachetul a fost publicat relativ recent, la sfârșitul anului trecut. Notele explicative de asemenea. Până când nu vom avea un pachet legislativ național de implementare coerent, complet, va fi greu să vorbim despre un nivel de pregătire suficient. Aș spune însă că n-ar trebui să fie foarte complicat, strict din punct de vedere administrativ. Eu cred că începutul va fi mai greu, dar pe măsură ce lucrurile devin mai clare și se rodează cumva noile reguli, n-ar trebui să fie. Ar trebui doar să vorbim doar de un hop acum. Plus că mai este problema oportunității. Până la urmă, noi ne putem îndrepta către această piață mare sau nu. Sau putem să o facem acum sau de la anul. Adică nu există o presiune de timp neapărat în sensul acesta. Adică putem să incorporăm aceste noi reguli și oportunități în strategia noastră pe termen scurt și mediu, aș zice. Dacă gândesc strict din perspectiva business-urilor din România. Un ultim punct aș mai fi avut, foarte pe scurt.
Da, hai să stăm pe concluzii, da, te rog.
Da, un ultim punct aș mai fi avut, chiar pe următorul slide, nu se termină aici, din 2024 mai urmează ceva, o modificare anunțată de Uniunea Europeană, o directivă nouă privind procesatorii de plăți, care vor fi obligați să raporteze date către autoritățile fiscale, unul din obiectivele acestor raportări fiind tocmai de a reconcilia datele despre plăți cu datele despre vânzări pe care le transmit comercianții autorităților fiscale. Deci e clar că asta este o zonă de interes, atât la nivel comunitar și o să fie evident și la nivel național, și probabil că vor mai urma și alte măsuri în zona asta fiscală, legată strict de comerțul electronic. Atât am de spus.
Putem spune că veți avea o activitate intensă în următoarea perioadă, nu doar anul acesta. Teodor, îți mulțumim. Gabriel, avem o întrebare pentru tine și mulțumim Liudmilei pentru aceasta. Care este impactul pandemiei actuale asupra cyber security și ce lacune au fost identificate? Sunt curios care e opinia ta de specialist. Evident, m-ar interesa foarte mult și ce ați văzut voi anul acesta. S-au scurs aproape 4 luni din 2021, al doilea an al pandemiei.
Da, e interesant și cred că aici ar fi cel mai important aspect este acela de shift al focusului de la zonele de corporate către home user. Da, mulți angajați au lucrat de acasă și încă lucrează de acasă. Probabil un trend care se va perpetua pe un termen destul de lung. Nu mulți își doresc să revină neapărat în birou sau nu tot timpul. Iar rețelele de acasă de cele mai multe ori nu au fost la fel de sigure precum cele din interiorul companiilor, da? Unde altfel de controale și bariere tehnice au fost implementate. Și știm de situații în care prin compromiterea unei rețele de acasă s-a ajuns chiar în interiorul companiei. Deci cred că un principal element ar fi această schimbare de la focusul pe perimetrul companiei la perimetrul de acasă. Bineînțeles, asta vine cu, iarăși ce spuneam mai devreme, cu un focus foarte mare în zona de educare și în zona de conștientizarea utilizatorilor ce trebuie să facă. Și asta e valabil pentru toată activitatea, fie că e ea de job, fie că e atunci când mergem pe astfel de platforme să facem tranzacții sau când facem plăți prin canale electronice. Cu siguranță, zona aceasta de atacuri la nivel de cybersecurity au crescut în pandemie. Practic am văzut atacuri destul de multe și în zona sistemelor de plăți, am văzut și în zona, chiar și în zona platformelor, am văzut în zona firmelor de curierat, da? Pentru că și aici activitatea s-a extins foarte mult și datele personale utilizate acolo au fost în cantități mult mai mari decât în trecut. Deci, practic, gama de atacuri s-a extins. Ce ar mai fi de menționat însă, cred că cel puțin la nivelul companiilor, chiar înainte de începerea pandemiei și ulterior s-a accelerat, a crescut nivelul de maturitate în zona de cybersecurity. Avem o multitudine de clienți, de companii care i-am văzut lucrează cu noi sau cu alte companii din piață pentru a verifica nivelul lor de maturitate în zona asta, pentru a fi siguri că potențial atacatori nu vor reuși să compromită datele lor, da? Și în felul ăsta să-și piardă încrederea din partea clienților și au făcut proactiv diverse acțiuni, proiecte pentru a crește securitatea platformelor, cele care sunt în special accesibile din internet sau pentru a crește securitatea datelor care sunt mutate din ce în ce mai mult în cloud. Deci, cred că un alt element ar fi această maturitate crescândă și sperăm să continue, pentru că în zona asta de cyber security nu e niciodată suficient, să spunem. Tot timpul apar noi vulnerabilități, noi oportunități de atac și e important să se țină pasul. Și exact cum spuneam și înainte, cadrul este deja prevăzut, există cerințe de creșterea securității din perspectiva autorităților, dar cred că e important, înainte de a ne gândi la acele cerințe și de conformitate, să conștientizăm fiecare unde avem riscurile din acest punct de vedere, cyber security, și ce trebuie să facem pentru a le minimiza. Cu siguranță, eliminarea nu vom reuși niciodată.
Mulțumim, Gabriel, pentru aceste sfaturi și o să mut discuția la Andrei. Andrei Săvescu, ai vorbit despre o nouă paradigmă în fiscalitate, te aștepți la anumite schimbări despre care ne vei povesti în cele ce urmează. Cum vezi și tu subiectele acestea pe care le-am abordat, legătura aceasta dintre fiscalitate și tot ce înseamnă digitalizare?
În legătură cu digitalizarea, mi s-a părut interesantă remarca lui Gabriel Tănase în legătură cu faptul că oamenii petrec mult timp pe rețele de socializare și mult mai puțin timp pe magazine online, și ca să păstrez tonul intervenției lui, pare totuși că rețelele de socializare sunt parte integrantă din e-commerce, pentru că mereu comportamentul meu pe rețeaua de socializare, pe Facebook, se regăsește în plasarea unor reclame tot mai bine țintite. Chiar și Netflix mă invită să apreciez filmele, spunându-mi că va încerca să-mi furnizeze conținut cât mai relevant. De aceea zic că faptul că lumea petrece puțin timp în e-commerce nu este ceva grav. E un lucru pozitiv că petrec timp pe rețele de socializare ca să furnizeze informații cu privire la preferințele de cumpărare. Mi s-a părut foarte interesant și intervenția lui Teo Artenie, care am impresia că subliniază o chestiune cu privire la care chiar aș vrea să știu părerea lui și îl provoc în legătură cu asta, dacă nu, înainte de a începe propriu zis intervenția mea, dacă nu cumva, Teo, ți se pare că asistăm la nivel de reglementare la o încercare din partea autorităților europene să deplaseze un pic accentul de la juridic la tehnic, adică de a ajuta conformarea punând niște constrângeri, uneori împovărătoare și obositoare, este adevărat, din punct de vedere tehnic și crescând rolul tehnicului în defavoarea juridicului. Ce părere aveți?
Îmi cer scuze, dar prima parte a întrebării n-am reușit să o prind. Au fost niște distorsiuni. Dacă pot să repet.
Ziceam că mi s-a părut că din expunerea ta a rezultat ceva foarte interesant, în sensul că autoritățile europene deplasează accentul de la aspectele juridice la aspectele tehnice, adică ajută conformarea juridică, impunând niște constrângeri de ordin tehnic. La fel cum, eu știu, de exemplu, este ilegal să pătrunzi într-un sistem informatic, nu-i așa, Gabriel? Este infracțiune. Este infracțiune, bineînțeles, și trebuie să ne ferim să facem asta, dar dacă ai un firewall puternic, nu o să poți intra. Adică există mijloace tehnice de împiedicare a unei conduite necorespunzătoare. Mi s-a părut că prelegerea ta evidențiază așa ceva și arată un trend la nivel european.
Așa este, da. Pot să confirm asta, mai ales în zona TVA. Există această discuție către viitorul TVA. Este un proces cu bătaie mai lungă. Regimul actual este un regim tranzitoriu care a fost implementat așa încă din anii 70 pentru că nu au existat mijloacele tehnice care să permită alte reguli, astfel că acum, în momentul în care avem tehnologia a fost testată, da, se va miza foarte mult pe această tehnologie, astfel încât sistemul de TVA pe care îl cunoaștem acum să se schimbe radical și să se ajungă către desideratul de a taxa orice tranzacție în țara de consum. Și da, prin intermediul tehnologiei, clar, nu se va putea altfel.
Gabriel, care e opinia ta?
Da, cred că asta este direcția și aș puncta doar două lucruri. De ce? Pentru că este mult mai simplu să poți face verificări de conformitate la elemente tehnice și atunci când sunt standardizate. Din acest motiv sunt aceste elemente tehnice impuse pentru că ele vor asigura standardizare, da? Și prin combinația aceasta de tehnic cu standard vor fi mult mai ușor de verificat și de urmărit toate aceste tranzacții. Și asta e și motivul pentru care se va avansa destul de mult în impunerea unor cerințe tehnice în acest domeniu.
Da, și eu cred la fel și mă bucur că suntem pe aceeași lungime de undă. Ce vreau să subliniez în intervenția de astăzi este o chestiune foarte simplă, înțeleasă de toți specialiștii și care cred că merită să fie înțeleasă și de publicul larg și acesta este și motivul pentru care încerc să promovez această idee. Mulțumesc încă o dată pentru invitație Business Review. În Europa, unul dintre principiile fundamentale ale dreptului Uniunii este principiul solidarității sociale. Iar acest principiu al solidarității sociale înseamnă că oamenii trebuie să existe cu toții, indiferent cum sunt. Ori, în materie de întreprinderi, nu oricine face business. Business-urile sunt chestiuni complicate, grele, necesită mult angajament, necesită implicare, necesită bani, necesită inteligență, necesită zile și nopți de efort, adică sănătate, în fond. din pricina, deci nevoile sunt atât de mari pentru că businessul este o treabă complicată. Există un impozit de complexitate intrinsec în orice afacere, dat de nevoile de organizare a activității oamenilor. Oamenii sunt adaptați să vâneze în haită, să cânte împreună, să se joace împreună, să facă dragoste, dar să coopereze la acțiuni complexe e ceva mai dificil și atunci ei trebuie organizați, iar organizarea este o resursă rară, prin urmare scumpă, iar prețul ei este plătit întreprinzătorului. Problema este că în afară de acest impozit de complexitate intrinsec, mai există un impozit de complexitate legislativă, respectiv statul, în încercarea de a-și colecta partea lui, în calitatea lui de asociat ascuns în orice business, se străduiește să colecteze impozit de la întreprinzători și una dintre modalități, în afară de cea bănească, este un impozit pe care l-am denumit impozit de complexitate. Impozitul de complexitate însă, care crește costul oricărui produs, complexitatea legislativă, fiscală necesită contabili care nu sunt ieftini, auditori care nu sunt ieftini, companiile la care lucrăm cu toții nu prestează servicii deloc ieftine și prin urmare nu sunt accesibile majorității întreprinzătorilor. Din acest motiv, din pricina că este mare impozitul pe complexitate, el poate fi plătit doar de către întreprinderile care au un prag ridicat de rentabilitate, care sunt destul de puternice deja. Prin urmare, impozitul de complexitate legislativă face curățenie în jurul jucătorilor mari, ucigând sau sufocând, dacă vreți, întreprinzătorii mai slabi, mai mici. Iar mi se pare că Uniunea Europeană a sesizat că aspectul pozitiv al acestei împrejurări, faptul că rămân doar jucătorii puternici pe piață, ca tendință, are și o latură negativă care trebuie luată în considerare și, dacă se poate, diminuată, și anume faptul că energia, spiritul întreprinzător, bucuria de a trăi și inițiativa micilor întreprinzători sufocați de impozitul de complexitate fac ca aceste resurse omenești pozitive să fie insuficient valorificate, adică mulți întreprinzători mici pierd în lumea business-ului și nu-și doresc să se angreneze în corporații mari pentru că, au probleme de personalitate, nu pot lucra în colective mari. În acest context, pentru a valorifica inițiativa micilor întreprinzători, mi se pare că Uniunea Europeană, în exercitarea principiului solidarității sociale, face o treabă foarte bună deplasând accentul spre conformarea tehnică, lucru care va permite energiei, inițiativei întreprinzătorilor mici să se manifeste în câmpul activităților sociale. Un exemplu tipic în această privință este platforma WordPress, ca să spun așa, că tot s-a vorbit mai devreme despre o firmă, dar care e atât de mare încât nici nu mai contează ce reclamă îi facem noi. Înainte să existe WordPress, cine vrea să-și facă un website trebuia să apeleze la specialiști, era complicat, trebuia să aibă niște cunoștințe tehnice, să găsească un server, să aibă niște cunoștințe minime de, nu chiar programare, dar de web design. În schimb, acum există tool-uri, WordPress și altele, care permit unui întreprinzător să-și construiască destul de repede un vehicul pentru afacerea lui. După cum există magazine online ușor de cumpărat, de închiriat, după cum există, marketplace-ul de la EMAG care permite întreprinzătorul să-și plaseze produse acolo. Adică vreau să spun că tehnica permite întreprinzătorilor să se manifeste eludând impozitul de complexitate inerent afacerilor. Asta era ideea pe care vreau să subliniez în această conferință și mă bucur că și coparticipanții din panel, colegii mei din panel au idei asemănătoare. M-aș și bucurat să știm și care este părerea ministrului în acest context, care să ne spună cum poate România să alinieze acestui trend european.
Ministrul Finanțelor nu va reuși să intre alături de noi, însă vom avea alături de noi pe un demnitar foarte important de la Ministerul Justiției în al doilea panel. Peste 10 minute intrăm în panelul de legal și, Andrei, te-aș întreba ce ar trebui să știe antreprenorii și managerii din zona tech, că am vorbit mult despre tehnologie astăzi, despre aceste posibile modificări pe care tu le-ai prezentat, cum să se pregătească?
Cred că ar trebui să nu plece la drum și să nu trăiască în business fără să aibă un contabil bun și un avocat la care se poate apela la orice oră din zi și din noapte, fără să aibă consultanță fiscală și juridică, pentru că pericolele în business sunt mai mari decât ne-am putea aștepta. Sunt mari nu doar pentru că sunt complicate legile, ci pentru că oamenii de afaceri au dușmani care, bineînțeles că te-ar scoate din business dacă ar putea, iar în acest context, deși cheltuielile cu consultanța fiscală și cu consultanța juridică nu par a răspunde unui nevoi imediate, în realitate, după părerea mea, sunt foarte, foarte, foarte importante. Sigur că dacă businessul este unul tipic, de exemplu, dacă, nu știu, îți faci o gogoșerie sau un chioșc de tutun, pe internet se găsesc toate informațiile necesare, nu e nevoie de asistență specializată. Însă, dacă businessul este un pic particularizat, este nevoie de asistență juridică, în special de asistență juridică, dar consultanța fiscală este de asemenea foarte importantă. Consultanța fiscală e de fapt importantă când nivelul de afaceri este destul de mare și optimizarea fiscală face sens, pentru că dacă cifra de afaceri este mică, optimizarea de 2% nu înseamnă mare lucru, adică e mai costisitor specialistul decât efectul. În ce privește însă asistența juridică, lucrurile sunt foarte grave, pentru că din pricina erorilor juridice se pot petrece chestiuni dramatice uneori, mergând până la chestiuni penale. Asta este ideea centrală. Întreprinzătorul trebuie să nu plece la drum singur. Trebuie să plece împreună cu prieteni specializați, dacă se poate.
Foarte bine spus, Andrei Săvescu. Aș vrea să încheiem cu o oportunitate și o amenințare pe care fiecare dintre voi o vedeți pe zona de fiscalitate, pe domeniile voastre profesionale de interes. Cumva sumarizând și ce am discutat în acest panel, ne pregătim pentru următorul panel, cel de legal. Intrăm într-o serie de prezentări foarte relevante pentru noi toți. Concluzionând, Andrei, Gabriel și Teodor, în această ordine, foarte pe scurt, o oportunitate și o amenințare, dacă ne uităm la ce urmează pentru mediul de business din perspectiva fiscalității.
Cred că nu o să vă placă ce o să vă spun. Cred că sistemul de control al statului încă nu este foarte bine pus la punct și încă unii întreprinzători se împrumută din impozitele pe care ar trebui să le plătească. Asta este o oportunitate care cred că mai durează foarte puțin. Cred că suntem în plin viraj al statului român în sensul civilizației, în sensul că nu va mai fi posibil așa ceva. Pericolul, prin urmare, dar e ceva firesc, nu este un pericol, este că lucrurile vor fi așezate mai în ordine și cu consecința că România nu va mai fi un paradis de afaceri pentru străini, așa cum este acum, nu va fi paradis nici pentru români, firește, așa încât cred că viitorul sună bine global vorbind, pentru populație, pentru România, dar pentru întreprinzători ar trebui să sune un pic încordat. Nu sumbru, nu sulfuros, dar oricum încordat.
Gabriel?
Da, cred că e foarte clar. Oportunitatea este de a ne muta cât mai mult în zona digitală și să putem, nu știu dacă am
Da, e în regulă, trebuie să continui.
Da, să ne mutăm cât mai mult în zona digitală și toți avem de câștigat din acest drum. Ca și amenințare, cred că datorită și cadrului legislativ, datorită mediului în care zona de cyber security și asta spunând în domeniul în care eu activez, vor crește astfel de riscuri, dacă nu le vom combina foarte bine, anumiți antreprenori sau companii pot fi afectate atât în zona de pierderea clienților, da, de neîncredere, cât și în zona de posibile riscuri de conformitate și eventuale amenzi. Deci, ele se întrepătrund, nu le-aș separa în această zonă. Oportunitatea vine cu posibilități de creștere semnificative, dar nu oricum. Va fi nevoie și de investiții pentru a asigura că această creștere e sustenabilă în zona asta de securitate, care la rândul ei va da încredere tuturor.
Teodor, o concluzie cu focus pe oportunitate și amenințări, în opinia ta?
Sigur. O să merg într-un cadru mai larg și o să întrădesc colegii de profesie și o să spun că legislația fiscală din România este plină de oportunități. Este una dintre cele mai prietenoase. Avem foarte multe lucruri bune acolo pe care le putem folosi cu succes. Aș spune că amenințarea este în același context complexitatea cadrului existent, dar și aparatul administrativ din cadrul ANAF și atitudinea organelor fiscale față de contribuabili. Aș spune că acolo pierdem foarte mult. Noi din mediul de afaceri, evident. Și statul pe de-o parte, pentru că, sigur, și nivelul de colectare este pe măsură.
Așa este. Unde lucrurile nu funcționează la o capacitate decentă și foarte bună, așa cum își dorește mediul de business, înseamnă că avem oportunități, inclusiv pentru mediul de business. Teodor, Andrei, Gabriel, vă mulțumim pentru acest dialog. Există o serie de modificări legislative care influențează zona aceasta juridică în prezent, iar în ultima perioadă în spațiu public s-a discutat foarte mult despre acest proiect nou de lege care să reglementeze protecția și recompensarea avertizorilor de integritate. Avem o legislație în acest sens, dar trebuie transpusă directiva europeană și știu că se lucrează la nivel guvernamental și la nivelul legislativului și despre asta vom discuta în orele ce urmează. Vor fi alături de noi specialiști, moderatori, experți în aceste domenii de activitate și mă bucur să-l introduc pe Mihai Pașca, secretar de stat în cadrul Ministerului Justiției, care este alături de noi de la Mindspace, acolo unde vom avea mai mulți speakeri prezenți împreună cu evenimentul nostru, eveniment organizat de Business Review. Haideți să vedem despre ce este vorba. Bună ziua!
Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond.
Your Excellencies, distinguished guests, ladies and gentlemen, good afternoon. We thank you very much for the invitation and for your kind understanding that the Minister of Justice, Mr. Stelian Ion, could not be present today due to a very last-moment change in his agenda. It is a real pleasure and an honor for me to represent the Ministry of Justice in the opening of this extremely well-organized event on such a timely topic like the extended protection of whistleblowers. At the present, the Romanian Ministry of Justice is very much willing to identify the most appropriate solutions in the legislation in the field of whistleblowers, including the need to effectively and efficiently transpose the European Directive 1937. In 2004, when the law was adopted, Romania was one of the European pioneers in offering a special protection to the whistleblowers as one of the main measures implemented in order to prevent corruption. Now, it is a new challenge for us to be again among the very first European countries that offer an extended protection to the whistleblowers, and maybe even more, to find the proper solution for Romania to implement a rewarding system. We are happy to underline that the negotiations on the European Directive 1937 were finalized during the Romanian presidency of the EU Council in 2019. As a member state, Romania has the obligation to transpose it until December the 17th. The steps that have been already taken by the ministry are as follows. The establishment of an interdepartmental working group, which decided by reference to the complexity of the provisions of the directive and analyzing the current legislative framework on the protection of whistleblowers, to draft a new law, not to amend the previous one. There was a first round of consultations with public institutions and authorities in August-September 2020. On March the 5th, the project was submitted to public debate by posting it on our website. In the decision-making transparency procedure, a public debate was organized on April 8, 2021, a debate that I was honored to moderate with the participation of representatives of NGOs and the business environment that brought valuable proposals, suggestions, and opinions that the Ministry of Justice will take into careful consideration. Unlike Law 571, that is applicable only to public authorities and institutions, The present project extends the scope of applicability to private sector, respectively to those with more than 50 employees. The scope of the draft is broader than the directive, in that the reports may address non-compliance with legal provisions, actions, or omissions contrary to law, including non-compliance with ethical and professional rules. Reporting channels established by law number 571 are maintained as internal, external, and public disclosure. Given the key role of whistleblowers in exposing and preventing violations of the law that harm the public interest, the draft law aims to establish a high level of protection for whistleblowers with additional rules and guarantees such as identity protection, prohibition of retaliation by way of example being invoked the suspension of employment, dismissal, changes in the work schedule, blocking of vocational training, negative evaluation of professional performance, intimidation, harassment, discrimination, and so on. Full repair of any type of damage following the reporting, which we consider to be a very important part of the whistleblower's protection, reversing the burden of proof, exemption from liability of the whistleblower in case of breach of the obligation to maintain professional secrecy, provided that the breach was necessary for reporting, support measures, and counseling of whistleblowers. As an element of novelty, protection measures are also guaranteed to facilitators, third parties such as colleagues, relatives, or the reporting persons or companies that whistleblowers own. The national authority implementing the external channel required by the provisions of the directive is the National Integrity Agency. This was established considering its experience in managing integrity issues. Also referring to the specific legislation, the project maintains the other external channels already regulated by other laws, as is the case, for example, of the Financial Supervision Authority, the Romanian Naval Authority, the Competition Council, and the National Bank of Romania. But also the possibility for the National Integrity Agency to submit reports for settlement depending on their subject matter to other authorities. Mainly, this is where we stand on transposition of the European directive. Further, we assure you all the interested actors of our entire support in order to have in Romania a very good European protection for whistleblowers. In this way, the Romanian Minister of Justice, Mr. Stelian Ion, has already had discussions with his political partner, Mr. Sebastian Burduja, member of Romanian Chamber of Deputies, in order to find together the most effective solutions that would be applicable in Romania. Please allow me to extend the Minister's appreciation, and my personal one, to the organizers of this event, mainly to Mr. Mike Costache. A big thank you, and thank you to all.
Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond.
We are going on with our second legal track, and we will present you a very short video with Chuck Grassley, US Senator.
I'd like to thank the organizers of this conference for inviting me to speak on the subject of whistleblowers. This is an issue that is very near and dear to my heart. The United States also has a long history of protecting and promoting whistleblower activity. The first whistleblower law in our country was established by the Continental Congress, and you might know that that was before our current Constitution was even written and our government was formed. Since that early years, dozens of whistleblower laws have been passed to root out waste, fraud, and abuse and corruption. Thanks to whistleblowers, Americans have recovered billions of dollars lost to fraud. It holds individuals and corporations who break law accountable for their actions. Simply put, whistleblower laws work. We recognize that in an open and free society, whistleblowers are patriots and serve a very important role by promoting government transparency and accountability. Sadly, though, whistleblowers are often mistreated, and their patriotic actions come at great expense to their personal lives and career. That's why it's so important to put very strong whistleblower incentives and protections in place. This encourages whistleblowers then to come forward and also protects them from retaliation by those who would rather not have the truth exposed. I commend you all for taking the time to put together this conference to discuss the importance of whistleblower laws. I encourage you to keep up the conversation and the debate. Remember this, the United States didn't pass the whistleblower laws. It has taken today all at once. It's taken us years, and we're still finding many ways to improve whistleblower protection in our country. So I wish you well as you continue your discussions about whistleblowers and whistleblower laws and their importance for very good government.
I'm happy to introduce one distinguished guest who is together now online, Stephen M. Cohn. Welcome to Romania through online connection. Our business community wants to know more about you and about this legislation.
Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond.
I assume we're on. I am sorry for any technical glitch that occurred, and I want to thank the organizers of this conference for this great presentation. The European Directive gives every nation in Europe an opportunity, once in a generation, to pass effective whistleblower laws. And I want to go over some of the central features of what makes a good whistleblower law and what should be implemented in Romania. Next slide, please. In the United States, we have a number of laws, and we can figure out which ones work the best. This quote is from the former chairman of the SEC, appointed by former President Trump, but it reflects the opinions, bipartisan, of law enforcement. And you can see what they're saying is by law enforcement and the whistleblowers, the key words here is working together. They have stopped frauds and prevented losses. Next slide, please. This slide pretty much sums up the impact of an effective whistleblower law. When we passed the False Claims Act, which is our best law, it rose in effectiveness. And you can see through this slide that between 1986, when we passed the law, and 2017, which is just the year this slide was made, whistleblower disclosures constituted close to 90% of all fraud recoveries. And you can see they were massive, over 56 billion collected in fraud recoveries. Next slide, please. And this looks at 1 year, 2017, in a snapshot, and you can see the whistleblowers accounted for 92% of all civil fraud recoveries. What that is telling you is that an effective whistleblower law can recover massive amounts of fraud, but without it, the majority of fraud and corruption would go undetected. In 2017, if this law didn't exist, 92% of the fraudsters would have become rich at the expense of the American people. Next slide, please. This shows the effectiveness of the law over time. It was passed in 1986 and implemented in 87. And you can see that every year more fraud was uncovered. This is because whistleblowers grew to trust the process. The government agencies effectively implemented the process, and over time it became very effective. Next slide, please. This is a quote from the Department of Justice official with the responsibility to implement the False Claims Act, which is our best whistleblower law. And you can see what he said. The False Claims Act whistleblower law is the most powerful tool the American people have to protect the government from fraud. I want to emphasize, he said the most powerful tool. Not an effective tool, not a good thing to have. The most effective. And that is the key, because fraud is designed to be done in secret. Corruption is not done publicly. Without an insider, without a whistleblower, you can't detect corruption. So if you want an effective corruption program, you need an effective whistleblower program. Next slide, please. These are just additional quotes that back up what the Justice Department says. This comes from the SEC. But what you can see here is really interesting, is because the head of the SEC says that the whistleblowers bring in high quality tips, blueprints, laying out the fraud. And you can understand why. If you have someone within the conspiracy, someone who works in the company that's violating the law or paying the bribes, they are in the position to give the best evidence. Effective prosecution. Next slide, please. And we can do the next slide. These were just more statistics. Next slide, please. And this is what a former Attorney General Holder said. And again, this reflects the consensus of law enforcement. False Claims Act provides ordinary Americans with the essential tool to combat fraud. The impact has been nothing short of profound. It has saved lives. It has put people in jail. It has stopped large frauds. But what's critical here is, what are those tools? What are the procedures and the processes that must be implemented to make this law work? And that's where the implementation of the directive becomes so important, because the way you implement the directive will dictate whether the Romanian people will have the tools they need to assist law enforcement and effectively fight corruption. Next slide, please. We can do the next slide. This is a slide that's very important, because one of our whistleblower laws, which is effective, the Dodd-Frank Act, has international scope. It covers the Foreign Corrupt Practices Act regarding foreign bribery. And what you can see here is that over 4,000 whistleblowers from 120 countries are now participating in the United States Foreign Corrupt Practices Program. All the countries in red are where the whistleblowers have come from. I show this slide because it demonstrates that people around the world want effective whistleblower protections, and when they get them, they will use them. There's nothing unique to the United States. If you create an effective program, it will work. Next slide, please. This is just an example of some of the sanctions obtained in the United States under this law from foreign countries, from foreign businesses that have been caught. And whistleblowers have been paid well over $50 million so far. International non-US citizens have been paid millions under this law. Next slide, please. And again, this is another quote from the former head of the SEC, appointed under President Trump. And he points out that the whistleblower is so important to find those well-hidden and difficult to detect frauds. And mark my word, corruption is always well hidden. Next slide, please. You'll be hearing from Bradley Birkenfeld, one of the most important whistleblowers ever. And what you'll see here is that his whistleblowing case for tax frauds triggered over $16 billion in recoveries and sanctions against over 50,000 US taxpayers. Why do I say this? It's because Birkenfeld's whistleblowing and the use of the IRS law demonstrated that you could actually tackle illegal bank accounts in Switzerland and other offshore places. Wouldn't it be wonderful if Romania passed a law that could actually force all of those people who are hiding their wealth outside of the country, not being taxed, hiding illegally obtained monies, if you could police that and sanction that and enforce those laws? It can happen. It happened here. It can happen in Romania. Next slide, please. And these are a series of slides that just further demonstrate the impact of the IRS law. Next slide. These are some of the banks that were forced to disclose U.S. clients and shut down U.S. accounts. Next slide. These are Swiss banks that were forced to shut down their U.S. clients. Next slide. And to summarize, to make the EU directive work, it's really just 4 basic principles that must be put into your law. First is confidential and anonymous reporting. The best way to protect a whistleblower is to hide who the whistleblower is. If the employer, if the company doesn't know who the whistleblower is, they can't retaliate. Second, you need an independent office. You need a professional, trusted office that will accept the whistleblower cases and coordinate the law enforcement response. Third, don't forget to have heavy sanctions on those who are corrupt. If you get caught in corruption, but get a slap on the wrist, it won't stop corruption. Our laws all have very heavy sanctions. Finally, you have to prohibit retaliation, which is laid out. And then you need incentives to get the potential whistleblowers to step forward. Next slide, please. And these incentives are so critical because a rational person is not going to risk their career, their jobs, their livelihood, maybe even their lives and safety, unless there's some form of guarantee that if they do the right thing, they will end up on their feet. They will be financially rewarded. The risk a whistleblower takes must be complemented with the opportunity to obtain a reward. And the rewards are only paid from the sanctions obtained from the criminals. No taxpayer money is ever given to the whistleblower. They get a percentage of the sanctions obtained from the crooks. The better their evidence, the better the reward. It's a perfect fit for law enforcement. It works as demonstrated above. So I want to thank you again for this opportunity. I want to thank the sponsors of the conference, and I look forward to hearing from Bradley next, a great whistleblower, and also to participating in the roundtable. Thank you so much. Bye.
Thank you, Stephen. I will go on and I will invite Bradley Birkenfeld, who is recognized as the most significant financial whistleblower in history. Welcome, Brad.
Good afternoon. It's a pleasure to be here. I hope you can hear me. I assume you folks can hear me. Just want to make sure.
It's cool. Yes. Thank you.
Okay, you can hear me.
Please.
For this wonderful opportunity to be able to speak about whistleblowing, not just because I created probably the largest whistleblowing case in U.S. history with the UBS and Switzerland tax scandal, but also because I am a Romanian heritage. My grandfather was from Romania, so I feel very proud to be here today to be able to speak about this, not just about Romania, but also about whistleblowing. And what my good attorney, Steve Cohn, just who spoke, and Dean Zerby were instrumental in implementing my case under the whistleblowing law with the IRS. This is a very important fact that people fail to realize, that whistleblowing is instrumental to a civilized society. I think there's many components that we can take apart from the whistleblowing laws, and Steve has delineated a lot of them, but I'll touch upon the ones that were really close to my case in particular, and what I've learned from many other whistleblowers around the world. I think it's important for everyone to realize that you won't need a whistleblowing law. You won't need the EU directive if people didn't break the law. But unfortunately, people do break the law. And you do need whistleblowing directive under the EU umbrella. And Romania has taken the lead here to go forward and to use this to show other countries in Europe that this is very important. Not just important for Romania, but for the whole country, the continent, as well as the European Union and the world for that matter. It's to show people that this will not be tolerated. Whistleblowing laws get implemented, they act as a deterrent, and they incentivize whistleblowers to come forward. But as Steve rightly pointed out, there's many aspects that have to be implemented. The anonymous factor, the lack of intimidation and retaliation, incentivizing as a percentage of the award, coming from the crime, not from the taxpayers, as Steve rightly pointed out. But more importantly, I think what we have to touch upon here, and in my case, I tried to correct the situation as a whistleblower internally, and that doesn't work because you're actually telling the people that are breaking the law about what you're going to do to expose them about breaking the law. So that's really not a viable route. The other very important fact here is that sometimes there's external sources, law enforcement, even media or nonprofits, and of course lawyers, that can help the whistleblower in this regard. Because sometimes whistleblowers don't know where to go, and they feel frightened, they feel threatened, and they certainly don't want to take the risk. And I think that's a very important component of this, where people have to understand the prudent approach is to understand that we must protect the whistleblower because the whistleblower is the one providing this invaluable information. And as I've always said, whistleblowers are clearly an extension of law enforcement. An extension of law enforcement in such a way that they should embrace one another. Whistleblowers with law enforcement can work very well together and to eradicate all the waste, fraud, and corruption that's around us. I think more importantly, when you look at some of the statistics that Steve Cohn had indicated in his previous lecture here right before me, you'll see that the numbers are staggering in the United States, but not just in the United States, but it also allows foreigners to use the system that has been implemented in the United States with all the different whistleblowing laws. Those whistleblowing laws have gone through many changes. They've been enhanced and then improved. And I think a lot of people today can realize the fact that they do work. Not only do they eradicate the waste, fraud, and corruption, not only do they pay the whistleblower, but they act as a clear deterrent to corporations and governments who think they can get away with this going forward. It's not going to be tolerated, number one. And number two, you're going to be exposed and you're going to pay a very, very big fine as well as possibly a prison sentence. So I think what needs to be done here is Romania needs to absorb some of these positive aspects that we've outlined here in the United States laws and just apply them in Romania. It's not that difficult. The bad guys are the ones who want this whistleblowing law to go away. The good guys and civilized people need this whistleblowing law. And the EU directive is critical in that regard because it's going to help everyone. I think the other important point to remember with whistleblowing is, in my case in particular, when I exposed the Swiss banks, that money came back from Swiss banks into US banks. That was the first point, and we stopped the illegal business from happening. Secondly, the money was invested and taxed forever, to perpetuity. So what that means is that you're essentially building a business back into your home country with the monies that were taken away for years and years. This is such an astronomical number, it's even hard to calculate. Why? Because the numbers have been in the billions of dollars, and the fact is that the banks now have had to come forward and expose all of their wrongdoing and get fined and penalized for that. The U.S. banks, of course, have benefited from this because the money's come back into the U.S. banking system. So the point I'm making about this in particular cases is that this is going to have a ripple effect for many, many decades going forward. So I think what is important for Romania is to understand that with whistleblowers like myself and many others who want to help Romania is to bring in a task force, bring in people like myself and these others in different areas, in pharmaceutical, finance, automotive, construction, military, and so forth. Why? The taxpayers are ultimately paying the price of these waste, fraud, and corruption antics, and we need to put an end to it. So I'm very happy just to work with Romania, work with the politicians there, work with the law firms and nonprofits to make sure that this is done properly. Romania can certainly lead the way here in Europe, which is quite an impressive statement that Romania is leading the way ahead of countries like Germany and Spain, France and England and so forth. Why is it that Romania is taking this lead? Because Romania sees that it is needed. And I think the other countries need to be pulled into the same mindset that Romania has, that they want this done, they need it done, and it's better for everyone. Some of the other aspects of the whistleblowing law that Steve Cohn had outlined that I'd like to touch upon are also helping the industry in which people work in to get this information and deliver it to law enforcement. The best thing about this is it saves so many man hours and budgets that would normally go spending on investigations that are very hard to uncover and hard to prove. But a whistleblower in that respect will work hand in hand with them to make sure this is done properly and efficiently. And I think the close collaboration between the whistleblower and law enforcement and NGOs and lawyers, of course, will help the whole system weed out the corruption. So I think, quite frankly, people have to understand that this is long overdue. Now, some people would argue that whistleblowing awards are unethical or they're not proper and so forth. Well, the problem with that statement is that most people don't realize what the whistleblower goes through to bring this information to light. For instance, their reputation, their livelihood, their finances, and certainly their job. So sometimes what will happen is they'll incur possibly depression, or they'll have large legal fees and so forth. And obviously some bullying and retaliation and harassment against themselves or their family members. So what you're in fact doing is incentivizing the whistleblower to come forward by giving them these payments from the crime they exposed. The crime they expose is very important because it never would have been exposed without the whistleblower. So that's critical to understand. The whistleblower is instrumental in making sure that this works. Law enforcement, of course, making sure that they prosecute the right people and move ahead is also important. So my point here is that people have to understand the magnitude of what the whistleblower can do. Think for a moment if you just eradicate all of the crime and corruption within these industries I discussed. And obviously, we're not talking about small pieces of corruption and waste and fraud. We're talking about, say, 100,000 or 200,000 euros and above, and greater than that as well, in the millions as well. But I think every industry has been polluted with this waste, fraud, and corruption, and they need to be addressed. And the best way to do it, the most efficient way to do it, is to look at the U.S. whistleblowing laws that have been implemented and are successful, every one of them. So let's see how we can take those programs and help Romania improve their society for everybody. I'm very happy to be here today. Thank you very much.
Thank you, Brad. One very short topic just before going on the next fireside chat. We are talking more and more about soft power and nation branding. In your opinion, what will be the effects in terms of perception at the global stage about Romania after the new law will appear?
Well, I would think that for me, as from heritage of Romania, again, I take great pride in knowing that I can try and help Romania improve. That's the first thing. And certainly my whistleblowing history speaks for itself. But I think what would happen here is, as a small country, relatively speaking, Romania will make such a statement on the global stage, number one. This is important to show people that small countries, like Romania versus, say, a Russia or a China, India, or Germany, or what have you, is that they're willing to take charge. They're willing to do what's right and make sure they empower their people to know that they're doing the right thing for them. Every Romanian should be very proud that this conference is taking place, plus the fact that this is going to get rid of the bad things in their society. So I think Romania has such an opportunity here to make such a statement, and other countries in Europe will have to follow Romania's role. So they'll go down in history as the ones who led the way. And we're happy to do that.
Steve, what is your opinion? What will be the effects, maybe regarding the perception of foreign direct investors about Romania? Bradley, very short. In the business field, what will be these consequences of new legislation, in your opinion? We will expect more new foreign investors?
Well, this is a very great question. I think you're absolutely correct that when foreign direct investment decisions are made by large corporations and multi-corporations, what they do is they see how stable is the country, how much corruption has been eradicated out of the country, because they don't want to open up operations, hire people, build factories, and invest millions of euros when in fact they don't feel as though that the system will work for them. So I think this is very important, that you're going to attract a lot of corporations and a lot of investment, because Romania is cleaning up this part of society, which every society has, through a solid whistleblowing program. And this will actually help not only unemployment to hire people, but also to build up infrastructure within the country, which before was a bit neglected. So this is a plus, plus, plus for everybody. And I think the Romanian government and the Romanian taxpayer should be very pleased.
Steve, will the new law will influence the role of our country, of Romania, at a global level?
Yes, it will. There is a premium on anti-corruption in foreign investment. Many multinational corporations have to follow strict anti-corruption standards. So a country that has good anti-corruption will be able to attract foreign investment and will also be able to protect its own companies and people from prosecutions. As I mentioned, the U.S. Foreign Corrupt Practices Act has now sanctioned tens of billions of dollars against foreign companies and foreign individuals, mostly now predicated on whistleblower disclosures. You can protect yourself, but also attract investment.
Thank you, Steve. I'm sure that we will see these good effects on local market, but also on international perception.
I was not able to hear the question, but and I'm now back on, but and just will reiterate that effective whistleblower laws benefit the people, the country, law enforcement, and it's really the only way to go forward in the modern world economy.
Thank you, Stephen. I will pass the mic to Mike Ostake, a very known manager, entrepreneur, and business consultant in Romania. Mike, the floor is yours.
Good afternoon and welcome to Bucharest, Romania, a wonderful country I was born in 43 years ago. The world is watching us as we are to become the first country in EU to implement a beautiful law the European Commission and the European Parliament have been working for many, many years. Today, I'm here with two esteemed guests who are experts in their individual fields. I have George Rotariu, who's a young entrepreneur. 7 years ago, him and his brother, Constantin Rotariu, started a little exchange called Bitcoin Romania. They've served 150,000 clients who came to learn about cryptocurrency from them. They have also the largest network of ATMs, and I'd like to welcome my friend George. Thank you for being here with us.
Thank you for the invitation.
On my right, I have a very esteemed gentleman who ran Romania's IRS, called ANAF. He also is a lecturer at the Romanian Notarial Institute and also a professor of law at the Alba Iulia University. Today, he's the advisor to the Deputy Prime Minister, Kelemen Honor, at the Romanian government. Today, he's here as a private citizen with a lot of knowledge and lots of titles, and we need to talk about something very important when it comes to whistleblowers, which is anonymity, protection, and rewards. Without these three elements, the law is useless. We've had Steve Kahn from America and Bradley Birkenfeld, who happens to be in Italy today. They've given us a lot of knowledge. But here we are in Romania, and we're trying to pass this law, possibly before other countries, and become a model country of how we adopted it. We used all of the knowledge that America and Washington has given us. But here we have two experts. And the questions are, do you believe that in the near future, there will be a cryptocurrency-specific purpose to pay whistleblowers to provide anonymity? Because today we have almost 10,000 cryptocurrencies, but should there be one specific for this purpose of anonymity protection of the whistleblower?
I'm sure there will be. I'm sure there are important projects already ongoing. And given the fact that blockchain is a great technology in terms of anonymity, I'm pretty sure this one of these projects will come out now, and especially maybe Romania being innovative from this point of view regarding this law will be maybe the country that will issue one of these projects.
Great, great. The fifth anti-money laundering EU directive states very simply that anyone transacting crypto, they have to report it. So if you do that, how do you derogate from this provision of the AML directive?
And that's a good question, because indeed all these transactions must be transparent. According to this anti-money laundering directive, there is no anonymity, and this is one of the reasons why these transactions were allowed finally by obliging the platforms to identify all the participants in the transaction. So I think this should be addressed by amending Law 129 of 2019. This is the law in which we transpose the fifth anti-money laundering directive, but we did not address this in the respective law. So I think it should be an amendment to the respective law, because otherwise that doesn't work. On the one hand, they should be anonymous. On the other hand, they should be transparent.
Right, right. So George, until we do get a specific cryptocurrency to help whistleblowers be paid to provide them full cycle anonymity, what do you think an alternative is among these 9,634 cryptocurrencies you see today on coinmarketcap.com?
Yeah, I'm pretty sure that the main cryptocurrency, actually Bitcoin, can be used as a way to reward whistleblowers, because Bitcoin already has a global infrastructure, and we all know that the personal wallets are not nominal wallets. Right. So until the receiver of the reward in Bitcoin decides to exchange the Bitcoins into fiat currencies, until then there is total anonymity regarding the name of the person that received the Bitcoins. So I believe that this is a very good alternative until a very serious project, global project will come up.
But there's a company in Florida called Chain Analysis. They just raised $100 million at a $2 billion valuation, and they have certain tools that governments use and other entities use to track cryptocurrency.
For sure, but if you anyone can create a wallet at any time, so we can create 10 wallets right now. Nobody knows that we created these wallets until I will go with my Bitcoins and exchange them through a cryptocurrency exchange like ours, for example, where we created an infrastructure and we have compliance departments and so on, where we basically get to know our clients, the know your customer, and also AML directive tells us to do so, even though until now is not amended in Romania. But yeah, until then, I think this is the best alternative.
Okay, great. So Romania in 2004 became the first country in continental Europe after England, which is not part of continental Europe. They became the first country to implement a whistleblowing law, only for the public servants, but it provided no protection, no anonymity, and no rewards, and it did very little. It was probably one of the cards that was put on the table for the then Prime Minister to allow Romania to become part of EU 3 years later in 2007. But today, we're sitting here and we're about to adopt the EU directive on whistleblowing with a lot of the recommendations that Steve Cohen and Bradley Birkenfeld and everybody in Washington at the National Whistleblower Center have been recommended to the EU for about 3 years now. So we're finally listening. But until that happens, today you have public servants that have to disclose their net worth every year, and if they lie, they go to prison, right?
Yeah.
So how do you address the issue of anonymity afterwards? Let's assume this law passes, we adopt it, and we provide anonymity, and a government employee blows the whistle on a specific subject, goes through the cycle, they get rewarded, whether it's in a cryptocurrency or in fiat. How do they then disclose this on their net worth forms every year?
That's a good question. Indeed, this law is from 2004, and of course, it doesn't work. From my knowledge, I think the last use of this law was 2 weeks ago when someone in the Ministry of Economy whistleblew about the lack of toilet paper and soap in the ministry. That was the use of this law.
Right.
So, indeed, we must address this because now all the public servants or the employees of the state must disclose their wealth by submitting a declaration, formal declaration, and they have to show not the wealth but also the components of the wealth,
right.
Well, like income, detailed
right.
income, the source of income, and even its fiat, even its cryptocurrency, you must disclose it.
Right.
So if you don't do something, this is specific for Romania almost, because not many countries have this obligation of posting all this declaration on the internet. So this is very public in Romania.
Right.
Other countries don't have declaration, or if they have, they are confidential. So they are put in a safe with an authority, and they check at the end of the term. They compare the declaration, but no, we disclose them publicly. So I think we must do also an amendment to the legislation of integrity in order to address these issues, because otherwise, of course, it doesn't work. So we must be careful when we put this legislation in place to accommodate this legislation with all different pieces of legislation that interacts with this one.
Or if they blow the whistle on a specific big project,
yeah,
and they eliminate corruption and they get handsomely compensated, maybe they do not need to serve the public, and they could take a portion of that and become entrepreneurs and philanthropists.
Yeah, but before that, they have to disclose it.
Exactly.
So
but after they get rewarded, maybe they have enough money from the reward.
Yeah. I know, but this is beautiful. But before that, coming back to our issue,
right.
They have to disclose it. And
sure.
The important fact here, if I can intervene, is that they don't get people don't get to know them as whistleblowers.
Right.
So I think that's the most important thing. So still, I think cryptocurrency is the solution. Like Bitcoin is the solution for now, and any future project that can be related to this law might be a very, very, very good add-on. And of course, I consider that in the law can be easily adjusted with saying, okay, if you whistleblow and there's something of national importance or safety of the citizens, or I don't know, corruption, big corruption cases and so on, it can be easily said that you don't have to specify that you received this amount from this, and that will
from this
not be
activity.
a illegal thing. Yes.
Right. Well,
I think you have to be careful not to leave something out.
Right.
Because we identified two issues,
Yeah.
but I don't know how many there are. So you have to accommodate this law with everything,
Right.
and you have to identify from the very beginning any obstacle, any thing that doesn't match.
Right. Well, I only know one project that's been working for 3 years. They've come to a lot of conferences, crypto-related. It's called Ethical Whispers, and they're looking to create a cryptocurrency to provide this type of anonymity all the way through the reward being paid out. But the beginning of our conference had 1 hour on taxation, and it was very, very technical and detailed. We had some wonderful people from NOR and KPMG and so forth. My question is related to taxes, since you know a few things about the system of taxation. And you ran Romania's IRS agency.
Normally rewards are not taxable.
Right. So this is one other issue that people are asking us as
No, they are specifically
and the minister Stelian Ion have been talking about this joint.
I don't know if he knows taxation, but
how do we tax a reward?
No, they are not taxable. So
perfect, because in America they are.
And how do you accommodate this with the anonymity?
Okay. You know, Bradley Birkenfeld received $104
Okay, so at least the IRS knows. At least the IRS knows.
And when they send the check, they gave him actually minus 20%.
I understand.
They gave him $75 million.
Yeah, okay.
It's his laminated bookmark that he gives anytime he gives a book away.
That's a withholding, yes.
So you just withhold it.
Yeah.
Can we do that here?
It's better.
Yeah.
It's not taxable here.
It's simple. Well, it's not taxable if you withhold it.
No, it's not a tax on this because it's a reward. It's like a donation. It's like a gift. So it's not.
Well, but
taxable.
so should pensions be like a donation untaxable? Why are pensions taxable? Sorry,
above a certain threshold, yes, they are taxable.
All right, great. Well, these are 15 minutes of attempting to break through a very important topic of will cryptocurrency provide the solution, and blockchain as a technology to providing anonymity protection while the reward is being paid. We're yet to find out. Stay tuned for our next conference, May 11th.
Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond.
Welcome back again. Right now, we're about to hit the most important topic of the entire EU directive, possibly being implemented or not. My good friend Bradley Birkenfeld came to Romania many times, and he tried to help by speaking at various conferences. And at the end of each conference, we would get lots of questions. And we would look at each other, and most people in the government would say, we can never do rewards in this country for one reason. There's no government entity to administer it. Well, the more they said that to me, the more I looked. And I didn't have to look far because in 2015, a very interesting agency was born, and our esteemed guest here, Cornel Călinescu, has been heading it. With only 30 employees, they have over 10,000 cases, and this agency, in Romania, it's called Anonymity, the acronym, but it really stands for the National Agency for Administration or for the Management of Seized Assets. And you won't believe that in 5 years only, with 30 people, they have 200 million euros that they're administering and they're managing. And there's much more to come from all the corrupt dealings of the past. So, the more government officials that ask me, where is your reward project going to be sitting at? Who's going to administer it? And the solution is simple. And he's here with us to explain not just that, but to also explain you a much bigger picture of what he's working on, which is the national strategy for recouping all the assets from crime. And that's a very, very big topic. And I thank you for coming and being here with us, because without you and your agency, we would have to invent another one. And it would take 5 years to create one. And we want to adopt this EU Whistleblower Directive this year. Be the first country in Europe, have all of Europe look at us and say, congratulations, we want to be like you. I want to be like Mike, is an old saying in America. People say Germany and Italy and France, as they're sitting on their yachts, all the members of parliament of all these big countries, during this summer, they'll look at this little country called Romania and say, how do they do it? One reason, we had people like you, we had people like Bradley Birkenfeld, we had people like Steve, who all came together pro bono on their own time, away from spending time in the weekends with their kids, and said, we want to do this. So, a famous US president once said, you're with us, or you're against us? Are you with us, or are you against the country and the future? So I'm going to give you now this gentleman who's going to explain to you why this is so important and touch upon some of the most important things when it comes to eliminating corruption, or at least reducing it as much as possible. Thank you for joining us.
First of all, thank you very much, Mike. Thank you for this great introduction. Also, thank you very much for offering me the opportunity to address to you and to the esteemed partners and speakers that are involved in this extremely high-profile event. I got the introduction, so no pressure. You are expecting almost nothing from my side. So I will try to cope with this and to take you step by step with how we see things going to the right direction, because the first thing that it's important is to have the right direction. I will speak today in this short time that we have at hand about where to take the money from. And our view is that we need to take the money from criminals. And this is at the heart of crime prevention policies that Romania is implementing. It's at the heart of organized crime strategies. And yes, indeed, it's also at the heart of the anti-corruption strategy. With your help, I will try to briefly present what this agency is doing. We have not invented the hot wheel or the hot water. We were established building on good practices from other jurisdictions. We have access to the experience of our American colleagues, to our French colleagues, to our Dutch colleagues, areas and jurisdictions where criminals do pay for their crimes. Next slide, please. What we are talking about, it's an endeavor that the Ministry of Justice is taking these days by promoting an integrated approach to the fight against crime, by putting on the front page of this policy the international cooperation and increase asset tracing and recovery. Also an emphasis on managing of seized assets, the support function that needs to be provided to the law enforcement and judiciary. And this will bring us also to some of the answers that we may have for the topic that you are addressing today, the social reuse and public reuse of seized and confiscated assets. Next slide. First, you need to understand that ANABI, it's an international partner for similar entities throughout the world. With our mandate in tracing assets abroad, but also in managing seized assets, we have access to a platform that reaches 70% of the globe. So first of all, we are an international partner fighting crime. Next slide. We are involved from the early stages of a criminal investigation until the final phase of a judicial trial, which is enforcement of the decision. And we are doing this by tracing for prosecutors assets in jurisdictions abroad, including offshore jurisdictions. We also manage the cash that is seized in criminal cases. We do host and organize interlocutory sales, and I just heard the topic that was discussed earlier. We are very proud that we are using a very advanced IT technology to offer for public auctions the seized assets, and also we have been involved recently in dealing and managing cryptocurrency. Moreover, we are involved in the final stages of the case. Once we have a confiscation order adopted by the court, we are talking about the social use and reuse of confiscated assets, and this will bring us to the topic of our discussion. Next slide, please. Mike touched upon this. Indeed, we are a young organization. We are probably the new kids on the block. We just arrived in this environment of institutions that are dealing with crime, prevention and fighting. But in this small history of our organization, we managed to reach a 1 billion lei portfolio, which reflects the cash that is seized in our accounts, also the assets that we are managing, and on top of that, almost 500,000 seized buildings in criminal cases. Next slide, please. What we are doing these days is sitting at the confluence of two major policy development procedures. We have on one side the EU initiatives for upgrading the organized crime and anti-trafficking policies, and we are part of this, but also we are part of this laboratory at national level of upgrading our policies in fighting organized crime and also anti-corruption. So from this point of view, the topic of your discussion, the instruments for making our integrity and anti-corruption instruments more efficient comes in a good confluence with our project. A few weeks ago, the Ministry of Justice launched for public debate a new policy to upgrade the National Agency for Management of Seized Assets, bringing solutions for making our interagency cooperation better by involving the agency from the early stages of the criminal investigations in tracing assets abroad, also by rethinking the mechanisms that we have now at hand in order to be efficient. Because indeed, with this new approach in fighting crime, we bring what is needed in this area of justice, the pragmatism of approaching from economical point of view the targets of criminal cases. So we are working now in intensifying the cooperation with law enforcement, with prosecutors, with the courts, to the extent that we make sure indeed criminals are paying, and they are paying with their actual money and with their actual stolen goods. And this brings us to the overarching topic of our policy, but I think this may become also an overarching topic for the discussion that you have today on whistleblower protection. One of the main ingredients of the national policy that we put on the table is making sure that not only criminals pay, but the money that we are taking from criminals are prioritized and they are returned to the society, they are returned to the public, the general public and the general good. And this is actually what will connect the dots of our discussion. Next slide. In order for us to be certain that crime does not pay, indeed, we are putting together an initiative to establish a national fund for crime prevention, which actually will aggregate all the resources from seized and confiscated assets into one major portfolio that will allow government to prioritize incentives for victim protection, which is an important part of any crime prevention policy, prevention, crime prevention, corruption prevention, and of course, education. We are working on this, and we are extending our invitation to the participants to this debate to work on this path to establish such an arrangement that will allow us to invest more in crime prevention. And if we invest in crime prevention, it means we invest also in mechanisms like whistleblower protection, like increased transparency in public administration, increased transparency in public expenditure, tools to deal with wealth declarations, conflict of interests and incompatibilities, and indeed serious crimes prevention. I think this arrangement and this aggregation of priorities will help us be more efficient in the fight against criminality, in the fight against corruption. And if this means indemnizing the whistleblowers to be more active, to be more keen in bringing out the scourge of corruption, then this might be a good idea for this approach. We are sure that by having whistleblower protection more sound, we can have also an increase in asset recovery area. So I think altogether, by putting all these pieces of the puzzle together, we can be efficient in our work. Thank you for your time. I'm available for questions. I'm available for follow-up discussions on this topic. Thank you very much again for the invitation.
Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond.
Hello and welcome back to the most important whistleblowing conference of 2021. The law is only passed when people come together and realize it's good for many. But first, you need at least one member of the parliament to listen to you, to understand the law, to be ready to fight the fight, and to allocate the time. And when you have 3 full-time jobs, like our good friend here, Sebastian Bourduja, has, it's very hard to do all of them, but he does them all at the sacrifice of his own family. He's here today to tell us what it's like to pass this law, or attempt to pass the law. As a member of the Romanian Parliament since November of 2020, it's a learning process. There's a lot of parties involved, but it's going to happen. He's also the president of Sector 1 for the National Liberal Party. He's also one of the 15 vice presidents of the National Liberal Party of Romania. He had the great pleasure of studying at both Stanford and Harvard. He then went to Washington, D.C. with his wife, who met at school, American, and they worked at the World Bank. And then they decided that Washington, D.C. was pretty far from Romania, where he was born. And he moved back here, and he attempted to do some good things. He achieved a few good things, and now he's going to achieve a lot more with the support of this coalition that both the National Party that he's part of, the Liberal National Party, and today he's here to explain how this law started back a few months ago and where it's going. So Sebastian, thank you for being with us. I know it's hard to leave your 3 jobs and your family to come here for 15 minutes with us, but the country needs you, and if you don't do it, I don't know anyone who can. So no pressure. Please enlighten our audience with what it's like to propose this law, to work together with the Ministry of Justice, to go through the many amendments, to listen to all the members of Parliament of both your party and others, and then how do we go from Romania to become a model country, adopting the EU Directive on Whistleblowing, to Romania has become by the time the summer comes. No pressure. Please go
ahead.
All right.
Well, thank you so much, Mike. It's a real pleasure. Thank you for your friendship and your kind introduction. Clearly, you're very biased, and you've said very many generous things. Some of them are true, many of them I hope to make them true in time, and I guess that's why we're here today. So thank you for organizing this. Thank you for making this happen, along with all the partners and everybody involved, both here in Romania and across the ocean in my other home, the United States of America. It's an important topic for sure, and it's a conversation that is not easy to have in a post-communist, post-traumatic context, I would say. And basically, we started working on this topic early 2021. And we knew there was a EU directive. We had heard the good stories of whistleblowers that are very close to us, like Brad, Birkenfeld, and others. And we were basically convinced by the evidence. Whichever way you look at it, whichever way you cut it, you have laws around the world that include essential elements like whistleblower protection and rewards, and they seem to be working. They seem to be delivering. And you also have laws for the protection of whistleblowers, and you have one in Romania today that clearly has not delivered as much as we had hoped for. And it's enough to give the example of the US. I think between 1987 and 2019, there were over $44 billion recovered as a result of whistleblowers, and less than $18 billion recovered in cases that did not involve any whistleblowing element. That's a clear case of supporting a strong legislation for whistleblowing, obviously based on the EU directive, but let's open up the discussion on how we can improve it, how we can add to it. And so we started looking at these different elements, and obviously the most important ones are also the most contentious ones. And you'll find things like whistleblower rewards, that's a big one, whistleblower enhanced protection, and ensuring that the whistleblower remains anonymous. Obviously, as I started this brief talk, you're inevitably going to run into a debate around telling on your neighbor. And for those of you who are not from Romania or some other post-communist country, Obviously, we dealt with very painful phenomena in Romania, where we had people telling the regime that other citizens were plotting against it or simply just listening to Radio Free Europe. And many people were hurt by that. But that has nothing to do, absolutely nothing to do with whistleblower legislation today. Quite the contrary. Whistleblower legislation, the way we see it, is a very powerful tool, and I would say an essential tool, to help fight corruption, to help fight abuse, to help fight different innovative instruments that companies and other consulting firms use to basically break the law. And evidence proves, again, and history proves, that if you don't have somebody on the inside, if you don't have somebody who blows that whistle, it's going to be really difficult to find out who's breaking the law. It's going to be really difficult to recover stolen assets. It's going to be really difficult to bring back that money, and it's billions and billions of dollars, euros, lei, what have you, every year. And so, obviously, this debate will go on, and thank you again for this opportunity to put out on the table different arguments and counter-arguments. And I know you've heard from very preeminent experts, and this will continue throughout the day. But to those Romanians watching, all I'm asking you is have an open mind, look at the data, try to go beyond the traumas of the past, of the communist system that went on for 4 or 5 decades in this country, and let's look at what this legislation can deliver for Romania. I would argue that in the form of best practices around the world, from the US to Korea to Canada to the UK, but even closer to here, to Slovakia, I think the Czech Republic, even Albania, I believe, have some sort of reward programs for whistleblowers. And consider if adopting such legislation for the country would be a good thing. I would think it's a good thing. I would think it will lead to major breakthroughs, to major recoveries of assets, to basically catching the people who are breaking the law. And oftentimes they're doing it for a lot of money. Again, it's not an idea, it's not a legislation, it's not something that goes after the small enterprise, the entrepreneur that's already sick and tired of all the bureaucracy and all the hurdles and all the hassles of the government. It's really something that goes after the big criminals, all the people trying to evade taxes, to move their money illegally, to basically break the law. And now, as a final comment on my part, what will happen next? We expect the Ministry of Justice to move forward with a proposed draft law. We'll look at it. Obviously, my team and I'd very much like to thank Cristian Dorobanțu, Bogdan, Mike Kostake, and all the other people, technical staff who have been involved in drafting this proposal. So we'll look at everything, and hopefully with your help, all of you watching will reach a point that has consensus or near consensus and makes a huge leap forward in terms of whistleblower protection in Romania. In 2004, and I'll end on this note, we were one of the European countries to lead, and we did lead, and we had one of the first pieces of legislation for whistleblower protection in Europe. It's time to lead again. Thank you again for this opportunity. Wish you all the best, and looking forward to all your thoughts, all your comments, all your feedback. Take care.
Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond.
Bună seara tuturor. Good evening to everyone. We have the first panel with 4 experts in Romania, and we'll discuss about what financial rewards related to whistleblowers. I have here Elena Calistru. She is the president and co-founder of Funky Citizens. Funky Citizens is one of the most active NGOs in Romania in the field of anti-corruption and also related to whistleblowers activities. We also have with us Irena Lorean. She is the researcher of Transparency International. Transparency International Romania is very much involved also in activities related to anti-corruption, and they monitored aspects of transposition of the European directive. The 4th expert with us this evening is Radu Nicolae. Radu Nicolae is the president of CNS Center for Education. Radu Nicolae works a lot in the field of transposition of this directive. He is the Romanian expert on the network related to the transposition of this directive at the national level. And also we have today with us Cosmin Sebastian, the president of Romanian Romanian National International Control Institute. Sebastian also is involved in the monitoring of this transposition of the directive. We'll start our discussion to have their perspective about the situation of a possible national rewarding system related to the directive and the level of protection that we can offer to the whistleblowers in Romania. We'll start with Elena Calistru, and Elena, please tell us your perspective related to this field of financial rewards for whistleblowers. Thank you.
Thank you so much. Maybe you'll have a perspective which is a bit pessimistic at the beginning. However, I think it's good to take the risks out first and then continue with the possible benefits of a reward system. I must say at the very beginning that my organization is focused on specific work with whistleblowers. We do have a project that involves whistleblowers from the healthcare sector in particular in reporting wrongdoings, corruption, and other issues that appear in usually in public hospitals. So from this practical perspective, I would say that a reward system seems to be a bit, I don't know if premature is the right word, but I think we should give a lot of thought and put a lot of analysis into such a perspective. Because in interacting with whistleblowers and in somehow facilitating their relationship also with investigative reporters, but not only, what we've discovered is that there is still a cultural stigma that is associated to the whistleblowing. So my fear and the fear of the organization that I am representing is that financial rewards would somehow feed into this pre-existing misconceptions sometimes about the role of whistleblowers. So in my mind, financial rewards are not necessarily something to take out of the question immediately. But I think we should take into account the possibility to see this as a further step after building awareness, education, and information in this regard, and after doing our best to make sure that we somehow consolidate a vision about whistleblowers as primarily those persons that are interested in the public good and not necessarily in getting a financial reward for what they are doing. So maybe something to to get us into a more optimistic perspective about potential financial rewards for whistleblowing would be to think about maybe innovative ways in which we could reward these people. Maybe in the case I was telling you about, think about rewards for the institutions or for the hospitals that they are working in.
Thank you very much, Elena. It's true that the situation in Romania and mainly in the former European countries is very controversial. Actually, Hungary already tried to implement such a system, and it was quite a challenge at the national level. It seems that at the European level, Latvia is the only country that successfully implemented such a system, a rewarding system that works very well. But as you mentioned, there was a very well promoted educational program informing the citizens about what the perspective of such a system, and also having a very well educational program and information about the new legislation. We'll go further and we'll have the perspective of Irena Lonan from the Transparency International. Irena, please tell us.
I see the debate about rewards for whistleblowers in a system or discussion putting together in the same perspective the motivation of whistleblowers and the trust of whistleblowers. To motivate whistleblowers, we probably need to reward them. To build trust with whistleblowers, we will need to build systems that will encourage whistleblowers to blow the whistle. In Romania, at this moment, we do have a stigma to whistleblowers that it's somehow a problem for their motivation. But here I do agree totally with Elena that probably paying whistleblowers a reward will increase the stigma, because in the Romanian history, speaking with the Romanian Securitate was related to getting a reward for that. So whistleblowers will be more associated with somebody that are snitches. On the other hand, another very big problem, and I think it's bigger in Romania now than the stigma, it's the fear to blow the whistle. Whistleblowers are afraid that they will lose their jobs, and they will probably not be able to get another job that it's the same or at the same level because they blew the whistle. So in order to build trust, I think that rewards are not the first thing that comes to our mind, or it has to come to our mind in a system. And what we saw in Transparency International in the entire world, and in Transparency International Romania's work, is that this kind of systems are lacking both in public institutions in Romania and in companies in Romania. We recently had a large research on business integrity, a business integrity country assessment that shows that most of the companies that are middle companies generally, so not the biggest ones, lack totally any system for whistleblowers within them. And the system needs to include the possibility to report anonymity, because whistleblowers are still afraid of being retaliated against. The fact that even if we encourage internal whistleblowing, this needs to be done in a way that will not discourage whistleblowers to blow the whistle externally or publicly, because they are afraid to do it internally, and they are afraid that they will be sanctioned because they didn't do it internally. This needs to include also very clear rules on investigating the whistleblowing incident and what happens to whistleblowers. This has to include also a very clear way to discourage indirect retaliations to whistleblowers, because direct retaliations are easy to identify and are happening in less cases than when the whistleblowing actually happens, when indirect retaliations are generally the rule. And this systems need to integrate a compensation for damages system. And then putting on top of compensation for damages a reward, then this can be something to discuss. But all the other elements in the system needs to be in place in order to encourage people to step forward and speak up. And when speaking about compensations and maybe rewards, we also need to think that research shows that people are in other countries, not in Eastern Europe, but in the United States, are motivated by rewards or by the fact that they will be compensated for their losses. The problem is that if somebody that it's not very well, top manager, very well paid, will think that they will need to go to trial for years and years and pay lawyers for that in order to get at the end compensation or rewards, or both. This can be a problem. So the compensation and or reward system needs to be put in place with very clear regulations on how to pay these rewards, the reverse of burden of proof, legal aid for whistleblowers, and so on. So there are many, many things to think about when we are thinking about rewards for whistleblowers, and this, unfortunately, it's not a silver bullet that will solve the problem that whistleblowers, at least in Romania, are not motivated, and most and foremost are afraid to blow the whistle.
Thank you very much, Irina. Is it true that Romania needs a better system of protection, and this system of protection has to go further to compensation, and also, as mentioned before, the part of education in order to avoid retaliation if there will be an awarding system? It's a very important aspect that we have to take into consideration. We'll go further and we'll invite Cosmin Șorbănescu, the president of the Romanian National Internal Control Institute, to tell us his perspective related to the financial reward system.
Thank you very much. What I want to bring to discussion is an internal control perspective. Implementing the EU Whistleblowing Directive in Romanian legislation is an act of cultural change, and also an important step in moving forward the civil power of society and the whistleblowers and link bearers to make their voice heard. Of course, there is a strong debate between rewards, incentives, or other motivations, in kind or quantitative motivations, not only financial ones. But before doing that, we have to implement a clear strategy and procedures between those public institutions and corporations in terms of strong ethical principles, anti-corruption programs, anti-bribery, specialists that have to deal with and investigate all the causes of non-compliance or irregularities that might come. So it is very important to have an internal control, compliance, anti-bribery and anti-corruption department that will take care of all these allegations. Secondly, when reporting or blowing the whistle regarding a non-compliance, it's also important to have some financial rewards. Not only because of the amounts that the state will have recovered and the assets that will be recovered through these perspectives, but also to motivate the persons to be able to speak up, make their voice heard, and also for the state authorities to receive prompt, immediate, and relevant information in terms of performing judicial action against, let's just say, the financial crimes committed. But of course, when taking into consideration the financial motivation, we also want to emphasize, I will also want to emphasize the non-financial incentives, which are very important. Because when a person is blowing the whistle, it also has to be recognized in mass media. It also has to be recognized as a trustworthy person that is not only making his voice heard, but it also tries to resolve a problem that the company has or even the society. So in this perspective, it's always beneficial to have a broader approach which takes into consideration all these aspects, and also on a continuous monitoring assessment to update the legislation based on the feedback received from the whistleblowers, based on the best practices that are recognized internationally, and also taking into consideration the local practice that we have here in Romania. Because in terms of anti-corruption legislation, Romania has made a solid move forward, but on the different perspective, on the cases that have been reported, investigated, and the assets or money recovered, we have to take into consideration serious improvements.
Thank you very much, Cosmin. Actually, looking into the international sphere and seeing the systems in different other countries, it's true that if we look into the American or Canadian system, it's true that this awarding procedure may improve the level of reporting and also the interest of the whistleblowers to challenge actually the system and to take the risks in order to talk about what's going on in a special institution. We'll go further with other discussion and we'll invite to answer the same question to Radu Nicolae. He is the one of our experts in this field. So Radu, please
Thank you.
have the floor.
Thank you, Sylvia, and I'm very glad we have this conversation, that it reaches the technical level. I don't know, you're not fan of the technical level discussions, but they are very important to have a good system that can be applicable. First of all, I totally agree with my colleagues. We have to improve the public image of whistleblowers, and I will come in the end with this idea. And also, it is important to get the fear out of discussion, because as Irina said, fear is an important factor, not blowing the whistle. And we have to see all these elements together. Protection, also compensation, also rewards, and what kind of reward system. But first of all, we have to be aware of the risk. There is risks. There is no, I think, it is clear that European Union do not encourage a reward system for whistleblowers. Such a reward system is not in the directive. What is in the directive, recital 30, is a distinction that the EU directive makes between informants and whistleblowers. And we have to be very careful on technical level not to pay whistleblowers as informants, otherwise we contradict the EU directive. So the language have to be clear enough in the draft law so that the system that we put in place ensures the whistleblowers are not informants of authorities. Why? Because there is a risk, an important risk, that rewarding whistleblowers that go directly to authorities will undermine the internal systems of companies. Because if the incentive for a reward is higher or is not proportional, then the whistleblower will go externally to the authorities searching for the reward instead of trying to solve the issues within their companies or their institutions. So we have to strike a good balance on this. In 2014, the Bank of England Prudential Regulation Authority issued a report that is, I think, the basis of why the EU directive does not provide anything regarding a reward system. They argue that, in fact, and this may be a factual thing, few whistleblowers in the end get a reward. We had a speaker before in the conference showing 4,000 tips that were brought by potential whistleblowers. There are thousands of people that blow the whistle. In the end, hundreds, even if they get in the jurisdiction that have a reward system. So we have to be careful not to create false expectations. That's the second risk I would mention. Then there is this moral hazard that may happen if you have a reward system that is not proportional. Then you will have malicious reporting or even entrapment. So we don't want that. So it's another risk that we have to be aware of when we draft the law on technical level. Some authors say that in weak states and where rule of law is not so welcomed, and unfortunately we are not the most loving rule of law state in Europe, but we are trying our best to implement. But I think Romania still has weak institution, and the reward system that is automatical may create corruption opportunities. That's another risk we have to take into consideration. But a part of these risks that we have to be aware of, we have to know them, we have to address them in the public discussion and within the technical discussion. There is room for alternatives. And what we proposed in the conversation with the Ministry of Justice regarding this directive, it will be to design a system that is not automatically, because I don't think Romania is able to do that, but a system that can acknowledge the value brought by the whistleblowing to the public interest. I don't know, probably involves money, but first of all, I want to see the acknowledgement. by the law enforcement, first of all, that yes, we cooperated with whistleblowers, yes, they helped us. In this way, they helped us. And this brings the discussion that I started with, namely to improve the image of whistleblowers in Romania. If law enforcement have an attitude and they are all aligned to say, yes, we used the reports from whistleblower, they helped us in this way, to acknowledge this in court, then we can think of a reward that will help us improve the system, improve the public image, and diminish the fear. But this, it's long shot. We need to carefully calibrate and draft this. But this can bring really value. Some speakers before our panel said about law enforcement attitude. They showed us example in US saying the general prosecutor said that, or someone else said that. In Romania, no one says these reports are important. So, first of all, we will talk also about the rewards, but first of all, we need this attitude within the law enforcement, within companies also. Yes, the whistleblower brought value to our company, not to say specific, but to acknowledge the values. And this is a good start for a discussion, a technical discussion of the reward system. Thank you.
Thank you very much, Radu. Very well underlined actually the risks that Romania have, and also they are very much linked to the culture and our historical past. We have some questions on the chat. Actually, we already have answered some of them. One actually comes very well after your intervention, and it's related to the level of transposition of the European directive and how it aligns with the other European countries in the transposition.
I can take this because I can advertise also the EU Whistleblowing Meter. It's an instrument, you can Google it. EU Whistleblowing Meter is done by the Whistleblowing International Network together with Transparency International Berlin. It's a great instrument. You can see there the states, their level of transposition. No one transposed it to be clear enough. So each member state is struggling with this arguments and technical discussion because it's not a simple directive. It needs to be adjusted to the local realities and culture in each state. We cannot copy the directive, that's for sure. If we don't adapt it to Romania, then we'll not be successful.
Is it true? Any other intervention related to this question? How actually the law? There is a question related to the transposition of the directive in Romania and what is the level. I can take this question and let know the audience that in the Ministry of Justice there is a draft law that transposes the directive, and actually on 8th of March recently we had a public discussion, and we try to incorporate the perspective of the business sector and also of the civil society in the draft law that is already under discussion. The deadline for the transposition is December 17th, but however we can extend this deadline if there is a need in order to have a very good transposition of the directive. We hope that we'll be able to have the draft law ready as soon as possible in order to go into the legislative system and to be adopted till December. There is a question specific for Transparency International, it seems that there is a surge worldwide in fraud and corruption. How effective is Transparency International in identifying root causes regarding to this?
Well, Transparency International, it's an international but non-governmental organization. And to the extent that what a non-governmental organization can do, Transparency International, it's probably the leading global movement against corruption. What we are doing, including concerning whistleblowers, goes in different directions. We provide research and advocacy, and research for advocacy that is done by Transparency International and by chapters in over 100 countries in the world, but also we provide research that it's used for advocacy but by other organizations. We also provide support for whistleblowers. Transparency International has something that in each country it's called ALAC. It's an advocacy and legal support center for whistleblowers. So we receive external or public whistleblowing and we use it for advocacy. We support the whistleblowers from the legal point of view. We are not lawyers and we don't provide the lawyer, but we support all the other elements that are not done by a lawyer during the process that a whistleblower is going through when blowing the whistle. And I take this opportunity to comment a bit on what our colleagues said and to provide some insights into research that Transparency International did and other elements of research. There is a fear in many organizations, including many Romanian institutions, but also many companies, that having a very strong system that encourage whistleblowers, that will provide very, very strong support and protection for whistleblowers, will generate a flood of whistleblowers, a large number of reports that cannot be checked, a large number of false reports, and so on. The research shows that none of this is happening. We are not actually in the danger of having too many reports, not even with a reward system that seems to be the most generous with whistleblowers, let's say. There is an increase in the number of whistleblowers when the level of protection is increasing with reward systems, or without, but with a great protection for whistleblowers. But there is not a drop on the quality of reports, so we are not flooded with false reports, and the quantity of reports can be investigated. So we are not in the danger of having too many whistleblowers. What we want to have is whistleblowers that have something to say about wrongdoing, and they are not afraid to do it, including whistleblowers that think they have something to say about something that it's a wrongdoing. They are mistaken, but in good faith they are going forward with that. And a protection system needs also to create enough protection for people that are in good faith mistaken, because otherwise everybody will be afraid that if they report something and in their report a small part it's mistaken, all the other being truth, they will be retaliated against and not protected. So I would say research, and including Transparency International research and all our experience in supporting whistleblowers, will tell us that we are not in the danger of having a flood of false reports if we provide more protection and even if we provide rewards.
Thank you very much, Irina. And having in mind what you have mentioned related to your research at the international level, I would like to ask Elena how the situation is in Romania, because I know that you are working very much on practical aspects and have somehow reports already from the national level. Could you Please let us know a little bit about the situation in Romania.
Well, I can mostly talk about what we're receiving from the healthcare sector, but I think it's quite a good case study, especially during these times. And I can also tell you about the various experiences that some investigative reporters are having with working with whistleblowers. Because I think we have reasons to think that more and more people are taking the the advice of the great philosopher Bob Dylan, and the answer, my friend, is blowing in the wind, and they are doing their best to do this, even though most of the preconceptions are telling them that they should refrain from doing this. What I can tell you is that we have noticed several trends. First of all, I know that it is important to also discuss about whistleblowing in the private sector. But if we are to look at the Romanian context, let's admit the fact that even if we are not only talking about public institutions, there are in more than half of the counties in Romania, the biggest employer is still the state, and that's a fact. That's statistics. So of course we need to focus on the special traits that we see in the public systems and in the habits and procedures of the public institutions. And then another important thing that we have noticed is that if I were to force a comparison, you know that when you're trying to bring kids to let's say a workshop during the weekend, they will not be so happy if you make them go to the school. But if you make them go somewhere outside the school, probably in a nice and flamboyant place, they will be more happy to do so. Not only during weekends, I would say that it happens almost all the time. The same happens to a certain extent also with whistleblowers. They know that they have the internal channels to report to, and that maybe this should be the first option. But they prefer going to the media, and then they prefer going to NGOs. Sometimes, in some cases, they prefer going to trade unions, but not in all cases. So I think that we should also acknowledge this specific trait that we can see as a trend in Romania. The third and final point I would like to make that we've discovered in our work is that people tend to understand their role and the importance of the Whistleblowing Act if they see others doing it. So I know it sounds like a very simple solution, but it's simple and effective. If for example, healthcare workers see that something has happened and an investigation was published following a report made by one of their colleagues, they would tend to do the same. And I think that the most important thing in this snowball effect is not necessarily the fact that we are getting more and more reports. The most important thing is that we can discover in this way what are the systemic issues that these whistleblowers are revealing. Because beyond what we see in specific cases, which can sometimes be, of course, a source of fury and maybe start extensive investigations. In Romania, you still have systemic issues that are somehow known, but when you put some stories in some micro data and specific examples, then maybe you can have a better argument for actually doing some things in these areas that stood untackled for so many years.
Thank you very much, Elena, for the national perspective, let's say, and it seems that we still have to build a lot or to work more on internal channels and trust, as you mentioned. So an alternative possibility should be a good possibility in Romania to be implemented. Before ending our discussion, I'll invite each of you to say a few words in the end and before having our final conclusion of the panel. And I will start with Irina this time, because Elena just said her final question.
Thank you. Thank you very much for the discussion. I find it very interesting. I think we have in Romania a good opportunity. It's a window of opportunity, how we call it, that it's not very often for whistleblowers to discuss it, discuss how to encourage, motivate, protect whistleblowers in a way that will be effective. And we have this window of opportunity due to the European directive and the need to transpose it. I think we don't need to have a perfect transposition. We probably cannot, but we need to do all of us our best to have the best regulation that we are capable of, and to be open to amend it on the way, seeing how whistleblowers or people that are capable of blowing the whistle in institutions and companies will react to what we will propose as a law. So I think we have the opportunity to create a system based on a new law that can be better for whistleblowers in Romania now, but I also think that we need to be open-minded to amend it as we are going, because we will see, and in all the other countries that have good system for whistleblowers, we saw that changes in time are improving the system for whistleblowers.
Thank you. Cosmin, please.
Yes, thank you. As a final conclusion, I think that the Romanian whistleblowing legislation sets the ground for reinforcing and advancing the anti-corruption mechanism here in Romania. Also, there is a strong debate and a dialogue regarding the best way to implement the directive, but I think that will be very important to take into consideration all the recommendations, the local customs and best practices, and also to have strong institutions that will monitor the whistleblowing mechanism, take the necessary actions, and find the resources to have an efficient and effective whistleblowing system, rewarding system, and also make this an opportunity to continue our strong endeavors in fighting against corruption and developing a sound and efficient internal control system which can overcome the difficulties we have till now in blowing the whistle, and also in helping us making Romania a better place for doing business and also for disclosing each and every non-compliance.
Thank you very much. Elena?
I think we are turned between the European and the American way, like in so many other cases, and I think we can make the best out of both worlds if we actually look at what can motivate the people in Romania to react. Because if there is something that's changed, and changed for the good in the past years, is that more and more people found the courage to say when they are unhappy with what is happening in public institutions or with public actions. More and more people understood that it's also up to them to change something. So I think we should use as much as we can from this trend and make sure that we, of course, transpose the European directive. I think it's a great opportunity for us, but also find possible innovations in the way in which we are addressing the role of whistleblowers.
Thank you very much, Elena.
On a final note, I would say that a good law, it's not the end, it's just the beginning, because we had in Romania many good laws, and we heard Cornel Călinescu just previously saying about social reuse. Yes, we had a great law on social reuse on 2015, and it was not applied. So we need pressure during the implementation. We need to continue our conversation as civil society after the law is passed to promote good implementation. So it's up to us, it's up to the citizens to make it happening.
Thank you very much. It seems that it's very clear that Romania has the obligation to transpose in a correct and in effective way the EU directive, and also to look into this European directive as a minimum standard, and if there is any opportunity to offer a better protection, because this is the most important aspect, to have very good protection of whistleblowers in Romania. This will encourage them to cooperate with the authorities to report the wrongdoing that happens in their institutions or in their companies. And the part of reward, award, motivation, however it will be, is under discussion, and we can think about the best that we can have in Romania. As mentioned at the beginning, Romania used to be a model in 2004. At that moment when Romania issued the first law on this protection, was the second European country. So why not? At this time, Romania cannot be the second again, because Latvia already has a system of rewarding and motivation. Why not Romania can be about the pioneering countries regarding the best that can be offered in this field? Thank you very much to all of you. Thank you very much to audience, and I'm sure that Romania is able today to have a good protection for whistleblowers. Thank you.
Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond.
Hello there and good afternoon to Bucharest. We're here with Business Review and Mike Kostash, and before we begin I'd like to thank both of them for inviting me to be here, the moderator, and also I'm sure the panel will as well. Romania has a very important decision to make. Legislation, or should we just keep it simple and say law, is a very important part of our daily life. What we don't want is law to be a paper tiger. It must be law that is actually used to fight crime, to bribery and corruption, organised crime. And as we know, nowadays, transnational crime is abound. So with Romania, this has a unique opportunity now to pass the whistleblower legislation based on what I believe will be the best way for Romania to go forward. As Martin Luther King said, the only way is to go forward. It doesn't matter if it's a run or a crawl, and this has to be with this legislation and other linked legislations. My name is Mike McNeil. I used to be in law enforcement in London, and I now have my own business here in Romania. I would just like to introduce to the audience, the panel here in the studio. Firstly, we have Denisa Simon, and she works currently for EY here in this building, as a matter of fact. And previously, Denisa was based within law enforcement, where she gained a vast and solid experience in various operations and investigations on a transnational basis and cooperation. Of course, the focus was on fighting financial crimes to bring money back so the criminal doesn't get hit too much with a prison sentence. Obviously, a prison sentence is important, but to hit them in the pocket, and transnational organised crime. She holds a unique combination of experience balancing planning and coordinating skills with a solid experience in institutional capacity. We move on now, please, to my other colleague here, Ioana Pitikas, who works for NOR law firm here in Bucharest. Ioana, so I understand, has been with NOR for about 4.5 years or so, and she is involved with white-collar criminal defence and civil law. She specialises in the assistance and representation of international and local Romanian clients in complex white-collar crime cases. She has advised companies from a wide range of industries in complex tax evasion and corruption cases, providing her clients with the most suitable strategy and criminal defence as well for their matters. Also in the studio here we have Madeleine Inash. Madeleine is the senior partner in the award-winning Inash Patir and Associates law firm here in Bucharest. Madeleine has hands-on expertise in business criminal law, compliance and regulatory matters and litigation. I have to say, in 2006, Madeleine practiced extensively in high-level white-collar crime cases with first-class professional expertise, amongst some of the most demanding and media scrutinised criminal investigations and trials. Madeleine has built up a solid reputation as a leading criminal law attorney, acknowledged by clients not just in Romania but also abroad as well, and has been compliant in many legal publications as well. Madeleine has counselled renowned Romanian international clients at the highest level and involved with a range of cases involving corruption, financial, fiscal frauds. And he is also a valued lecturer on criminal law and has published some publications himself. Not present here, but virtually, is Bogdan Fratioloi, and I do apologise for any of my English pronunciation there. Bogdan is currently a compliance manager and director for Roche Pharma and Diagnostics, where he's been for over 5 years. He's responsible for implementing the compliance framework within Roche Pharma nationally and abroad, and includes corporate and healthcare GDPR. Bogdan has an extensive experience in compliance and has gained experience in various multinational companies, including Ubisoft Entertainment, Telecom, OMV, and of course Roche, Hoffmann Roche. His working partner with AmCham here in Bucharest and has been involved in many activities in the compliance field, including presenting documents to the Ministry of Justice to sort out and design national anti-corruption strategy and knowledge on compliance and ethical topics. We now move on, please, to a colleague who's over in the States at the moment, Simona Vasilia. Simona works for KPMG US, and she's a director there, and she currently is, if you just bear with me just a moment, please. She currently, do apologise. She's based in New York. Simona assists clients with global employment tax income and also social security compliance needs and tax. Previously, Simona was with KPMG in the UK and was the tax director. So you can see that we have a very distinguished panel here in the studio and around in the States and in Romania. So I have some questions, and if I can start off with Denise, please. We have, what I plan to do is to give you one question, and then the rest of the panel one, and then we move on to the other questions there, if I may. So how can we create, Denise, a secure environment for employees to blow the whistle within the company rather than to external sources?
Well, first of all, the companies have to ensure the anonymity of the alert. Also, they have to create a secure, healthy, and stable work environment for the employees to feel valued and to feel that they can go forward with their complaint. So also, they have to be supported. How they can be supported? Well, the best way would be for the company to give them the resources that they need to feel supported. One of these kind of support would be for the company to give them an IT tool and to give them the possibility to fill the complaint online. We already know from our experience that throughout the time, the companies created systems that were ineffective. Well, we had hotlines, we had email addresses, but they were ineffective because the hotline was sometimes busy. The person who was calling was feeling afraid that he will be recognized, or the person who's on the other side of the phone will not understand the complaints or will not properly understand what is the purpose of the complaint, what's the content of the complaint, what are the expectations, what are the needs of the whistleblower. So the best solution would be for the company to provide an IT tool where the employee can go and can fill in the complaint. It's 100% confidential. What does that mean? Well, this means that there is no physical connection between the employee, the whistleblower, and no physical connection. You're not going in front of one of your colleagues. You're not going in front of HR. You're not going in front of your boss. You're not feeling ashamed. So the second advantage of an IT tool would be that you're all by yourself with your thoughts, with the complaint, with what you're asking for, with the support you're asking for. Also, you can track your complaint. You can see the status of the complaint. You can see the status of the investigation. You can actually see what the team is doing for yourself, right? For you. Also, you at the end of the investigation, if an investigation will be started or any kind of process is going to be started, you'll be aware of what's happening behind, right? You'll have a resolution at the end of the investigation. You'll know for sure that someone is taking care of your complaint. Someone is taking care of what you were saying. So the best thing would be to, first of all, to engage the employee or the whistleblower, to engage him in the actual investigation. This means that with the IT tool, you can actually have an anonymous chat with the employee. You can ask him questions. You can ask him to upload within the tool to upload additional documents. These are vital for an investigation. If you only get at the beginning, if you only get few lines, because you know what, the employee is not an expert in filling complaints. Maybe it's the first time when he's filling in a complaint. So he fill in few lines saying that he's unhappy about the way things are going. It can be legal matters, it can be, I don't know, criminal offenses that are happening within the company. It can be harassment, any other problem that he's facing. But if you give him the chance to respond anonymously, like giving him the chance to upload the documents afterwards, or to ask him to clarify some aspects that he was put in his complaint, he will feel much more comfortable to go with his complaint within the company, but not to external sources, like going to the what are the reasons that people are going, or the employees, whistleblowers are going to, firstly to the media or to the authorities, because he is not feeling supported, and the interest of the companies are to support the employees, to solve the problem, to create a healthy, secure, and safe work environment. So just to go back and to highlight what I said before, the IT tool would be the best solution for the companies now that we have a new EU directive. The IT tool will ensure 100% confidentiality of the person who's coming forward, will engage the person in the investigation. Also, will make him feel comfortable. He will be aware in real time about the status of the investigation. And finally, the most important thing is that he will get a resolution. Most of the times when you fill in a complaint, you don't get any answer. You don't know what happened. I mean, when you call a hotline, you're just complaining about what's happening, but you'll not get notice that your complaint is being taken care of. And at the end of the investigation, or at the end of the analyzing of the complaint, you'll not get any confirmation that someone took care of your complaint. We also, our company developed such tool. And there are plenty of tools on the market. Every company can choose depending on their needs. Every company can choose and can customize. And they can choose any tool available on the market depending on the needs, and they will find an IT tool that is tailored for their needs.
Thank you very much. Certainly, one of the things in law enforcement, when someone comes forward and gives information, especially in the old days, similar to whistleblowing, people wanted that reassurance that what they said wouldn't be given to others, because it's quite often it's obvious that that person is the person given the information, the due diligence really, if you like, behind it all. So you need to know that, yes, it's a very good tool, and hopefully people will take it up, because it's all about confidence at the end of the day. Okay, Ioana, if I may move over to you, please. Okay, so what are the main aspects a company is supposed to consider after implementing internal reporting channels?
Okay, so I think the discussion is quite long, and I think it's normal for companies in the private sector to now focus on implementing the right procedures if the law passes and when it passes. But the problem is, what are we going to do after that? And there are quite a couple of things I have in mind right now, and I'll try to pinpoint the major ones. One would be the fact that, in my opinion, as a compliance specialist, companies will have to completely reform the way they look at fraud cases and fraud suspicions. I mean, you have the right procedures in place, but you do need to be aware of the fact that you need to tackle fraud cases differently, like you did before in the past. Because given this whistleblowing directive, companies really need to be aware of the fact that once the local law passes, they will have a register and they will have the obligation to keep a public actually not public, it's going to be a private register, but it's going to be open to authorities in case of any scrutiny or control. And those registers actually will show every case of potential non-compliance or breach of law that was committed. And companies need to be, exactly like my colleague said, they need to be aware that they need to implement this correctly and actually use it to their advantage. The other main aspect I'm thinking about is the fact that, in my opinion, as a criminal defense lawyer, it is definitely going to change the way criminal investigation bodies and courts of law are going to deal with the fact that in Romania, companies can be held criminally liable. I think this is a major topic that can be linked to the discussion of today because since 2006, companies and organizations can be held criminally liable exactly like an individual, right? So it's not only the individual or the perpetrator itself as an individual who can be held criminally liable, it's also the organization. And the very interesting part is in the fact that if we were to analyze, and I think you can probably confirm, because on the left side of the panel you have the lawyers, right? If we were to look at the court decisions by which a company is convicted, you can always tell that the number one thing courts of law look at is the efficiency of the compliance system, right? So on the way you implement this and the way you actually tackle your internal issues, this is gonna actually play a major role if you get convicted as a company or not. I've actually seen and collected quite a few very interesting court decisions in which courts of law actually state that when appreciating the guilt of an organization, opposing to appreciating the guilt of an individual, they look at the compliance system. Is it in place? Is it efficient? Does it actually work? Have you done everything you can? Did you invest the necessary resources according to your size of the organization and so on and so forth? So I think that from a compliance/legal perspective, these are the two main aspects companies are definitely supposed to consider.
So it works really hand in hand then, doesn't it?
Yep.
Really, compliance, and it's certainly something I touched on myself earlier on this year with KYC and financial crime as well, and crime seeps into every corner of our public society, and it's up to us now, and it's up to the Romanian authorities here to make sure that this law goes in as good as possible, to make sure that it's understandable for everyone, because law can be quite shall we say, difficult to understand.
Yep.
So it's like in plain language as well, so people understand, they know the rules and regulations straight away, they feel comforted, but yes, firms, vicarious liability if you don't do it, and yes, it works hand in hand. But the other thing I think also works hand in hand, and I think with Denisa and I from the past with asset recovery as well, is the fact that if you have the whistleblower and they're successful with the prosecution and they get their rewards, shall we say, hopefully in this particular case, that also that the criminal itself will actually have their assets seized as well, in addition for the bank, for, shall we say, like in Bradley's case, UBS, they have the sanctions, but it must also have the individual have a confiscation order, their assets seized, otherwise there's no point.
Yeah, but just to add something to what you said, I mean, what you exposed in the beginning is really interesting, because you mentioned, of course, it is really important to give the whistleblower an idea of the fact that his complaint is being taken care of. It's not only important on a psychological level, it will actually prevent probably the employee from unnecessarily communicating confidential information in the public space, which is something I think every company in the private sector wants to avoid if it's not necessarily or justified. But the trick here is, it's not going to be just for the comfort of the whistleblower, it's really going to help you establish in front of a court of law if you can be held criminally liable for an offense or not. So there are two major aspects on how efficient you make this process actually in your company.
Okay, thank you very much. Madeline, moving on to you, as you're here in the studio, then we move over to the other guys. So, changing the organisational chart and internal policies as a result of the Whistleblowing Directive law. What's your point?
It's a very, this topic is a very big concern to me, for instance, as a practitioner, because, like Juana said before, it is very clear that criminal convictions of moral persons, of companies, usually come from too dispersed responsibility in relation to a certain decision, or too little things done in order to prevent situation which can be of a criminal nature, which can be of an administrative nature, of a civil nature. From my perspective, okay, I'm a criminal lawyer, but I have to think, having contact directly with the employees in companies in different internal investigations, it's very similar to probably what UI does with the forensic investigation department. It's pretty similar to what criminal attorneys do when confronted with a criminal case and having to prepare in order to understand what has happened within the company or being involved in an internal investigation. What needs to be done from my perspective, from a practical perspective, because if I were a CEO of a company, first of all, I would be interested in knowing if I have any sort of issue, be it criminal, be it civil, be it from a labor law perspective, because I have a harassed employee. Okay, we are in Romania, where the previous law in the public field of, I don't know how to call them, I would just say it in Romania, avertizori de integritate, because they're not actually whistleblowers. They were supposed to be something like whistleblowers, but it never happened. It just remained a labor law situation. It was just a law that you can find quoted in very few criminal cases. But coming back, you have to contain this problem and keep it internal, because as someone said before throughout the day, it's very important to have the employee or have the whistleblower understand the importance of the internal mechanism, and this is why you have to create this mechanism, and you have to change your philosophy, like Juana said before, and it's very real. You have to change your philosophy in order, first of all, to tackle the problem, if you are interested in tackling the problem, but to understand very well that if you don't do it, someone else will. And this someone else means media exposure, because it's probably the easiest way nowadays with all this media in all these many forms for a whistleblower or for someone who is discontented with what happens within his work environment to go to the media, be it Facebook or primetime TV. But second of all, you have this exposure in terms of your reputation, which can be extremely damaging, especially since more and more companies go public these days, go on, make IPOs and so on. But second of all, you have the authorities who can come in. And for many crimes, there is no obligation, and I'm speaking as a practitioner now, maybe I'm on the other side for sure than the two of you before, but for many crimes there is no obligation of disclosure, so you can handle it internally. And I've been involved in many investigations in which situations have been dealt with internally, within the framework of the law, of course. And you can do that in an effective manner in which to ensure your company runs better for the future. And second of all, you don't get mixed up in a procedure, whatever it is, fiscal, administrative, even criminal, in which everyone loses, because this is what usually happens. So basically, from my perspective, the change of an organization because of this law, because I'm also of the opinion that this law is a very good project. It's necessary to have it, not only because it's a directive in the back of it, but for the simple fact that we have to understand that ethics is the way to run business. So ethics must not be just a letter in a rule, in an internal organizational chart. You should have trainings. You should have people informed effectively, not just signing on a piece of paper that they have been informed about what they can do, about what are their rights. And you should put in place a system, because even if I fully agree with what Denisa said in terms of having a system, an IT system, in which to register the complaint or the whistleblowing, this has to be doubled by a human touch. Because seeing clients also from this perspective of whistleblowers, and we've had a few cases, we have one nowadays with one of the ministries of the Romanian government, in which the whistleblower is of course marginalized and put in a corner, and there are labor procedures against him and so on. That person, indifferent of how he managed to register his whistleblowing, was neglected as a person. And from my perspective, this is what is lacking from the law at this point in time, the human touch. Because furthermore than just the whistleblowing, which ensures the public interest and which helps a company or a public authority get better, generally speaking, you have to consider that there's a person behind, And also seeing from the examples which you have in the States with whistleblowers and how they were marginalized and how they were put in the corner, how they were sued for what they had done with the very best intent, this has to be, we have to learn from others' experiences, as someone said, because this is how we show we are smart.
Most definitely. And sorry, so you wanted a question on top?
No, I want to add something. Can I?
Yeah, please.
Okay. So that's a very, very good point. What I want to add and to clarify is that the IT tool, or let's call it like a virtual compliance officer, will not replace the human touch. Absolutely. I mean, this is something that comes additionally in support of the actual compliance officer. So the compliance officer will still exist and he will still do his job, but this comes as a support of his job. He will do better his job because he will be aware of much more what's happening inside of the organization. So his job will be doubled by an IT tool.
Okay. This is what I mean also.
And maybe something else.
Yes, please.
I don't know what your experience is, but I do seen a big fear in people when dealing with complaints in general. I've seen this in Romania, and it's probably because we're an ex-communist country, right? Every time someone thinks about filing a complaint, they just get scared. They usually refrain from filing such a complaint, although they have a lot of arguments to file it. It's a justified complaint, and I see them panicking, and I see them getting so fearful. And I do believe that probably, I do understand what you're saying, probably if the first contact is a bit tempered and you don't see the human side, but it is there, you just don't see it in the beginning, it might literally help to ease up the psychological issue and actually help implement the correct whistleblowing process.
But it's all about explanation as well. Yeah, at the beginning it's going to be more IT, but also it also goes down to making sure that you know what the process is, and certainly, you know, beforehand, you know, I've had people before, no one explained to me what was going on from A to Z. Of course, sometimes you've got to be flexible in between because other ingredients push it another way. But yes, the human touch is important as well, because sometimes you have that gut feeling that you can't have from a computer. But also at the same time, one thing I noticed from earlier this year is you know, from work, is that with employees, you know, do they rarely check that the background checks of the employee as well? You know, you have to take that into consideration as well, because some firms just tick a box. Oh, that person said they had X certification. Bang, no, they haven't. And things like this, and I think that has to take a place as well. Why is that person doing the whistleblowing? Do they have a grievance about someone else? But also at the same time, what else is going on that we don't know about? What's their background? Why are they there?
And you'll go into the first discussion that a lawyer might do if I were that lawyer, going against a whistleblower, because you have to consider also this perspective,
both sides,
to show the bad faith, because otherwise he's no longer a whistleblower.
Yes.
He becomes someone who takes revenge, because as we were discussing beforehand with one of our colleagues today, you have a law in which also a former employee can be a whistleblower and benefit from the effects of the law. So when you have a former employee which might have left in not so friendly situation, maybe there was something there, you just decided to part roads, and then he becomes a whistleblower against your company, then that makes you even more vulnerable as a company to such a situation.
You know, this is a huge problem. I mean, I wanted to point it out, but I was actually a bit scared. I do understand companies from the private sector fearing this law. It's understandable, because I've never seen a company where everyone is happy. So there's always one employee or several employees who are dissatisfied, frustrated, completely against the working environment or the management decisions, and they do file a lot of complaints and lawsuits which are unjustified. And I think this is a risk we're going to see in the future. What's going to happen is the fact that companies will need to be aware of the fact that they will have probably an increase in unjustified lawsuits and complaints. This is just, in my opinion, the way it's going to play out, unfortunately. Every good law has a bad side, right?
Of course, and of course, you know, in law enforcement and the legal side, you have to look at both sides of the coin, you know, to make sure that you do the best.
But in a very interesting way, the draft law, as it is now, offers no protection for companies in the private sector with this regard. We have only, as private companies, we have obligations to implement the directive, but literally no protection against a potential abuse of angry, frustrated, unjustified employees. And maybe this is something the draft law has has to take into consideration. Every good law can be abused, as said. It's
exactly. It
the way it
does
is.
have to be amended slightly.
We'll move part of the complaining process, which usually now goes to the ITM, to the Labor Inspectorate, which goes to the state authorities, police, prosecutor, which goes to the administrative authorities, which might check the company. All this will be doubled, probably, because I don't see anyone formulating a complaint, first of all, internally. When they do it, they usually go all the range, all the spectrum of everybody which might be involved, and you have it doubled internally. And this means, just like Juana said, a lot of resources allocated and a lot of costs allocated. Of course, you can explain it, you can understand it. It is a cost which has to be considered because we have been accustomed to not take these measures, and it took FCPA investigations in Romania and took foreign companies to come here and to change this environment of how businesses must be conducted, and that there are these types of costs which you have to consider. But on the other hand, you touched the subject of course that I wanted to touch. Just as a practitioner, you see it because you can understand very well how this type of law, which goes to the core of, one of the core problems of our society, which is corruption, which is abuse, whatever form of abuse, from civil to criminal. And then I wouldn't, as a practitioner, want to see the opposite side, in which, and I'm not speaking for the big corporations which go against the small employees, which are always fearful, but anyway, there has to be a balance. And there has to be a system of checks and balances, just like in any other field of law, in which to have also something internal, but to also have a third party, which may be a court of law, which may be an authority. Because I don't see what happens next after this, after the first investigation, whatever result is given to that. Whatever result, what happens next? You might have some court of law if it's a civil, administrative, fiscal, or you might have a criminal complaint, a criminal denunciation, more or less, which then, and you get to the same point as you did before, you just have like 6 months as an employee to try to tackle some problem. You have 6 months as an employer, as the company, to try to cover if this is what you decide to do, or to try to see what you can do to patch things up. These are things which have to be considered because the law is very good in its core. But even though Solon, I think, said that the best law is the simplest law, yes. However, in our nowadays society, I'm afraid of misuse of legislation. Because we've had misuse of legislation before, and I can speak freely here, it's the abuse of power crime, which has been misused in all these years from a criminal perspective. And we've seen cases of abuse of power went into the private sector. I wouldn't want to see this law become another tool in reinventing cases of abuse of power.
Thank you very much, Madeleine. Simona, hi. Can you hear me okay?
Yeah, can you hear me?
Yeah, we can't hear you though at the moment.
Can you hear me?
Yes.
Yep. Perfect.
Okay, cool.
Okay, I will try to be very loud.
Sure. Thank you very much for joining us, Simona, virtually. I'm conscious that you have another official engagement soon, so if it's okay with the other panel, can I do the three questions all in one go?
Same here. Thank you so much for having me.
Okay. Simona, 3 questions for you. I'm sorry to put them all in one bundle, but what can you highlight and what should we leverage from the US whistleblower legislation?
Sure. First of all, thank you for trying to introduce it at the beginning.
No worries.
I want to clarify that the reason why I'm here is the fact that I'm an enrolled agent with Internal Revenue Service. And I have a master in taxation with the law school where we have studied this quite in depth. Because for the US, this is a very, very important law. And I have really practiced that in over 20 years of experience with KPMG as a tax partner across industries in both private and public organizations. I think it boils down to a value system. And in the US, this has been very, very important for a long, long time, because really the US whistleblower legislation is the federal government's primary litigation tool in combating fraud against the government. We even have a US National Whistleblower Appreciation Day, which I highly recommend. It's on July 30th. And it's basically linked to the fact that the first whistleblower protection law was issued in 1778.
Yeah. I understand that was with the British prisoners of war, wasn't it? And the American commander, if I remember.
It comes from something you probably heard again and again today, hitam, which is a Latin term, which basically says that the person who fights for the king fights for himself. You hear it nowadays translated in, if you see something, say something. So that's why all the Americans are trying to do the right thing. So just to come back to your original question, why should we leverage the US system? And I don't know if you can hear me very well, but it's basically a reward system. And it's very well documented, so it's a law. We have actually a series of law and amendments to it. It has started with the False Claim Act or the Lincoln Law, and then it really evolved in something called Whistleblower Protection Act, which is a federal public law since 1989. And the reason why it's so important is because it has all three pieces you want to have in a law. So it's both covers the constitutional aspects of the legislation, the criminal and administrative implications. So I think our session right now wants to go deep into how we can make this Romanian law real and have processes and procedures around it and make it administratively viable, so it becomes embedded in our day-to-day life without side effects for the people we're actually asking to be informants or whistleblowers, and for the companies and the people who are not doing the right things to actually be punished in a fair way. So I don't know how much we need to define this from a Romanian legislation perspective, but in the US, to state the obvious, a whistleblower is a person who exposes information on an activity that is deemed illegal or unethical. And it has really focused a lot of time on anything from law, rules, regulations, gross mismanagement of funds, waste of funds, authority of even endangering public safety or health. So it's embedded in almost every single aspect of the society, and it covers a lot of ground. And believe it or not, when you go to the IRS website, it's only in one section. So the entire original legislation body, you probably read it in 5 minutes. It's section 7623, which you can really Google and read it even by the end of the day. It's a beauty to read because it covers all the points that you actually have addressed today. And it's simple to digest for everybody.
Thank you, Simona.
No problem. You had a second question for me?
Yeah, and a third. So, what aspects of the US whistleblowing tax processes and procedures create the reliability and success we have heard of and seen in the media?
Thank you. I think the dollar value was the piece that was like the most. Because for the last couple of years, I think they rewarded over $60 billion. Like if you go and look at the report for 2020, for 2020 alone, which was a COVID year, they had over 9,000 claims, out of which over 550 were actually paid. And some of them, probably more than 150, were linked to major issues that really needed a $2 million in penalties, tax and interest. So this is a proof that the system works, even if you don't have to physically meet someone or have the day-to-day life in a COVID perspective. But really what I would recommend in addition to the big whoppy rewards that the US government has offered, is the fact that they do have that process very nailed down. So they have a treasury regulation which is active, they have an internal revenue manual, actually I believe they have 2 of them. Everything is online on the IRS website and everything is really, really detailed. So all of the questions that you raised in the first part of the panel with how are we going to do this, how are we going to do the technology, how are we going to do the work, how are we going to protect individuals from retaliation, how do we keep things sealed versus public. Everything is really, really documented to the comma in those manuals and everybody's aware of them. So I highly recommend for the legislative body of Romania who is going to look into putting a very solid law in Romania together to look through those sites which are available to public and take whatever you feel necessary that applies to the Romanian market, because sometimes you can't pick and choose things from the US because it's a different country altogether, but there are lots of useful information there for people to leverage from. Again, one important piece that was added recently, which was discussed earlier in the panel by everybody, was that retaliation and how you really protect the individuals coming forward. There is something called No Fear Act. It was issued in 2002, which requires all employers to have a mandatory annual training. So I can tell you, I've been 20 years in the US and I took 20 trainings already on how to really retaliate and how to protect people coming forward, trying to fix issues in existence.
Thank you.
That's just one example on how it works.
Can I just add a very quick question for you? In December, the new US Anti-Money Laundering Act was passed just before the handover of leadership as well. Whilst there is independent policy and law on both sides, will that have an impact on this? On the whistleblowing?
If you think about everything in your legislation impacts directly other pieces of the way we do business, I think ultimately the anti-money laundering legislation, the whistleblower legislation, and any other protective legislation in this way is really boiling down to create that integrity and the easiness of doing business in a country, as well as increasing the transparency and collaboration between parties. There is a big push around privacy of data. Everybody's exchanging data right now with a huge pace. And I think we will see more and more legislation that allows us to really define what is personal information, what do we protect, what is public, and how do we go around this.
Thank you very much.
Is this answering your question?
It does, thank you. And sorry to throw that in without you knowing that particular question. But,
no worries.
It sprung to mind as we were talking. Your last question, Simona, is what are the rules for getting a whistleblower award in the US and how are such awards taxed?
Yes. So first of all, the awards are not capped. So anyone can earn an award up to 15 to 30% of the amount that the government collects as a result of this claim. I think you had a very famous speaker in the panel today who has gained tremendously from the system. The downside of this is that you need to pay taxes on it. So the reward is considered taxable income. And it's really not taxed as a capital gain, but it's taxed as ordinary income rate. The beauty of the Romanian tax system is that the income tax rate is lower. You don't need to pay the very high rate in the US and probably even higher as Biden is trying to change the law. But you do have a withholding obligation when you receive the award. So you typically, for a US citizen, the payer withheld 24% of the award to make sure that they have enough withholding throughout the year. And then if you're a foreigner, you are not a US citizen or a green card holder who's typically not filing a US return, but you see something in the US and you want to claim on the award and you get the money from the award, they typically withheld the 30% or they apply the exemption from the 50% that might apply.
Thank you very much.
So it's, all in all, it's fun.
Definitely is. It's all change all the time, always moving forward. Can I just ask Simona as well if Bogdan and the guys in the studio have any questions for you, if I may ask?
I would have a question, if I may, Simona. Yeah. So given the fact that you have a lot of experience with this and we actually are newbies in this regard, what would be your first tip for us to teach our clients and private companies that they're supposed to use this law in their advantage and not fear it that much? Because I do believe this is going to be the reaction companies will actually have. I would use your knowledge in this regard to get a bit of comfort out there.
I think we need to talk from two angles and expand your question. So first of all the foreign companies coming into the Romania, and I won't generalize, the majority of global companies are really already implementing this and they have it in their core value system and in their processes and procedures with their employees. And really what they want to see is support locally so they can really strengthen their internal culture with their employees and make it normal. And from the Romanian companies who are new to this environment, I really think we have done so much progress coming from the communist regime where everybody was telling us what to do, to really being a libertarian culture where the individual is so important and the sky is the limit of the opportunities we can actually create in Romania, that if we don't have this system in place, we have a lot to lose. So I feel like we should not be afraid of doing the right thing. Because if we create the ground protection around the people who want to do the right thing, we will all benefit from it.
Thank you.
Thank you very much, Simona. Thank you very much for your time, and good luck with everything over there in the US.
Thank you so much. It was a pleasure having you. Thank you for everything.
Thank you. It's our pleasure too. Bogdan, I do apologise for leaving you to last. I do apologise. I hope everything is okay, and thank you very much for joining us here this afternoon. Okay, so Bogdan, I have 3 questions for you, but I'll give you one question and then we'll go round to the other guys again. So, how important is it to ensure that the potential breaches are to be reported anonymously?
First of all, good afternoon, everybody. Can you hear me?
Loud and clear.
Yeah, excellent. So, thank you very much for the invitation. And it's a pleasure for me talking with you on whistleblowing and compliance topics. Yeah. So, I had the opportunity to hear very interesting opinions, starting with Denisa, and in my opinion, anonymous reporting is essential. Because, as we know, many cases, many non-compliance cases in the case of most severe compliance incidents in the last 20-25 years, starting with Enron case, with Armalat case, Deutsche Bank, and many others, Barclays, were reported anonymous. And it's easy to understand the why behind. In most of the cases, the CEO of the company is involved, the GM might be involved, and usually the big and severe cases occurs at the very top of the companies. And permitting to report anonymous, for sure, in certain situations, in certain conditions, namely to provide some details and to be trustful reporting, is essential to have a good start in a compliance investigation. And also, I would complete here with the importance of the non-retaliation policy, because in many companies there is a whistleblowing policy, sometimes incorporated in a larger business ethics directive or SOP, and regarding non-retaliation, in just a paragraph mentioning that the company assures non-retaliation policy and the protection of the whistleblower. And that's all. And according to compliance best practices, it's advisable to have a separate non-retaliation policy, and here I would underscore the role of the compliance officer, because the compliance officer is responsible to assure the non-retaliation policy and the effectiveness of this policy. And we need a policy with clear provisions, with sanctions for the representatives of the companies which may take actions against the whistleblower. And in this way, the compliance officer should be powerful enough to investigate a case of retaliation against a whistleblower, because, as we know, there are various ways to harass or to attack, let's say, a whistleblower. Many indirect ways, not only to fire him or to cancel his position, but there are sometimes, let's say, indirect ways, like, for example, to change job responsibilities, to change job description, to assign him duties which are not in his expertise, and in this way to force him to leave the company or to harass directly the whistleblower, and in this way to intimidate other employees to report non-compliance. In AmCham, in the Corporate Governance Committee of AmCham, and I was the deputy chair in the last 3-4 years, we had the opportunity to develop together a very good document regarding the role of the compliance officer. And it is absolutely important to have a powerful compliance officer which is able to report at the top of the company to the GM or the CEO, and to have a dotted line to the chief compliance officer of the group in case of multinational companies. And in this way, also in the piece of legislation proposed by the Ministry of Justice, we had a meeting with them in AmCham and we proposed this, and probably in the implementation rules of the law, these aspects will be taken into consideration. Because otherwise, as our previous speakers very well underscored, the piece of legislation will not be an effective one.
Thank you very much. I do concur with you, Bogdan, that compliance is part of one of the keys to success, really, with whistleblowing and other pieces of legislation, of course. And of course, one issue that I've come across personally is the fact that some firms' computers don't talk to one another, and they don't have an effective system, to check, red flags on people, whether they're a PEP and so forth as well. And I think, with the compliance officer having those tools, then it's less time for them to discover things and more time to investigate and, as you say, to report it up the line if need be. Thank you, Bogdan. Denisa, back to you. So, how can public institutions and companies define their approach towards the obligations arising from the new EU directive on whistleblowing?
Well, everything I'm going to say, I'm going to put it in a human, from a human perspective, right? As an employee, what you're expecting from your employer. So there are two types of companies: the ones that already have a system in place for the whistleblowing process, and companies that don't have any process in place. So both of them, also the companies that already have a system in place, which now, according to the new directive, can be considered ineffective, as is not complying totally and is not covering, is not protecting 100% the identity of the whistleblower. All the companies have to be sure that they implement a methodology, an internal process, also that they let their employees know that all the complaints go through a triage and they're being considered. also, the companies have to organize regular trainings, as Simona was mentioning before. Mandatory trainings are extremely important, as sometimes the employee, when he's attending a mandatory training or a training that is organized by the companies, will think that it's all about himself. Oh, the company knows about the abuse I'm suffering now, and they only organize the training for myself, or to solve the problem, or to convince me to go forward. So all the companies have to truly organize their steps. If they don't have an internal investigation department already, they have to think about an external source for investigation in case the complaint they're getting is more complex and it implies legal issues. Also, even if the process of implementing all these is can be considered as being costly, in the long term, you'll save a lot of money, because you'll avoid the penalties, you'll avoid for your reputation to be affected. And as Bogdan was mentioning before, going to the CEO or to the general manager, I don't think is the best solution for the companies, because they do have to have an audit committee internally that must handle these kind of complaints, or they have to have an external neutral consultant that can handle the investigation.
Thank you very much. And certainly training within firms is mandatory as well. And of course, when new employees come along, that has to roll on to them. And of course, it has to be kept up to date with various legislation changes as they happen. And also, I think one thing as well, to make sure that people understand, because there's a lot of e-learning out there now, and people, bang, 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 on the computer. But it's also to have a knowledge check at the end of it as well, to make sure that they fully understand the risks, not just for them, but their employees and the firm they work for. Hopefully that will change. Okay, moving on to you, Ivana. Will there be any differences in how companies are supposed to react when faced with internal fraud allegations?
Definitely. So, in my opinion, this is something that is supposed to start now. Companies are supposed to really think how they are treating fraud and fraud suspicion at this point. What I see in my day-to-day practice is a lot of companies who more or less ignore such fraud suspicions. And the reasons why they do it, they're quite complex. So you see companies who decide that if they come forward with a fraud case to the authorities, nothing is going to happen. Prosecutors are not going to react in a timely manner. They are not going to recover the damage they suffered anyway. So why do it? Some just find that fraud is inevitable, so why bother looking into every single one of the fraud suspicions if it's going to happen anyway? I think it's something that's also related to the Romanian culture, because probably other countries will have other experience with this topic. So what I would suggest company at this point is something that's supposed to be different in this regard, is really reconsider how you treat these fraud cases and these fraud suspicions, and start now, because when the law passes, as mentioned before, you will have a register, and every complaint that employees will file will have to be in that register, and in case of scrutinies and controls, authorities will have the right to look over that registry. And my opinion, people will, and that's actually the purpose of the law, people will find themselves encouraged to use this law and benefit from the protection granted under. And this is a huge, this is a huge red flag for companies who are probably not so focused on their compliance system at this point. This is what they're supposed to change. Maybe a good idea for companies in the private sector would be to start with a basic risk assessment. This is what we usually recommend. Perform a risk assessment, see where your vulnerabilities are, see those departments where there's a higher risk of fraud, and fix the problem. Fix the problem and fix it now before the law passes.
Exactly. Thank you very much, Ivana. It's certainly, the key is to make sure, that, well, you have to get ready right here and now. Don't leave it to December. Yep. You have to do it now. In fact, now is getting on. You know, we're what, 8 months away before Christmas even. You know, so effectively in between them we have Easter and other sort of holidays as well. So people need to get moving right here and now. Madeline, over to you again. So please tell me. Sorry, just bear with me. Yeah. Internal mismanagement, situations, investigations versus whistleblowing notices, disclosures and the rights of the whistleblower. What can you tell us?
Yeah, when I proposed this topic of discussion, which was partially brought up in the different panels today, and it's only not natural that this happens because we are a lot of people with a lot of perspectives, and it's natural that everybody comes with its own input, with its own opinion, depending on the work experience, basically. What I want to say, and to link it with what Juana said and Denisa beforehand, it's very important to understand prevention. This is a topic that criminal lawyers say it over and over and over again, and not only criminal lawyers. As a criminal practitioner, I recommend to the clients, especially corporate clients, prevent, because if you come to me in the 12th hour, it's more difficult to deter everything or the consequences of what has happened internally. Second of all, in terms of internal investigations, my main topic of interest is not necessarily the criminal implications of a certain action of an employee, for instance, or of one of the directors of the company. Because if it's about the GM, probably there won't be a whistleblower going internally. He will go externally. On the other hand, there are already in place criminal procedures and criminal procedure provisions which provide the framework in which this can be exercised already. I would rather go to the ethics issues, which are very difficult to tackle, and it's a very subjective discussion, and the difference between, for instance, what you have nowadays, the new trend in labor law cases, moral harassment, for instance, or what you have in terms of poor conditions or cutting someone off from promotion and so on. Because that's also a topic of this legislation. We are talking over and over again about anti-corruption and fraud. We theoretically and practically have legislation on these topics. We should go to what whistleblowing means. Whistleblowing means seeing something unethical. This is the core of the idea. If you see something illegal, you already have hundreds of years of culture, legal culture, in what you should do. I'm not going to refer now to the famous quote from a famous movie, but the idea is, first of all, create the framework in which this can happen. Because if you are interested in having an ethical business, then this is what you have to do. Have an actual working environment, procedure in which this can happen. Second of all, even you can internally reward employees who actually, by their whistleblowing or by their, I don't know, I'll call them intimations, make your business better, more secure, more ethical, more clean. And third, and most important, ensure that everything can be dealt with. And this is what I also said before, try that when the situation hits the fan, so to speak, to have someone, a third-party expert, be it a consultant, be it a lawyer, maybe both, have someone objective come in and handle the matter. Because at some point in time you might not see the situation which is in front of you because of different subjective reasons. You know that employee, or you know a certain situation, you understand a certain work environment which requires bending the rules. But if you are faced with such a situation, then you have to handle it. And if you cannot, or even better so, don't worry yourself with something which you could outsource. Okay, it's costly, but think of the pros and cons of this, and think of the consequences that, for instance, you have a whistleblower which is not happy or satisfied what you told him, you tell him in your response, be it 3 months or 6 months after he made the intimation, he will still go to the authorities. So you have to tackle a new array of situations that beforehand we saw in the American movies. Now this is the reality, the economic reality in an ever-changing business environment in which European or international is pretty much the same as Romanian. So we have to play by the international rules, no longer by just the Romanian laws and regulations or customs, which, as we all know and all say, we are Balkanic, we can move to the left or to the right depending on how the ball falls. It's no longer the case.
Thank you very much, Madeleine. I certainly concur, but by making businesses more transparent here and elsewhere, of course, but with Romania, then more businesses are likely to flourish here in Romania and therefore create a better environment for everyone as well, and therefore hopefully reduce a little bit of organised crime, that people don't go and be human trafficked as well. But of course, yes, there are some times though where sometimes you have to be even flexible thinking as a whistleblower, and I'm just thinking that if you're in that organisation and that the people that you want to say what you found, you've discovered that the unethical thing that you've seen, sometimes you can't go to the manager, or you can't go through the system because people will destroy evidence as well, and this is the problem. And of course you want to have the evidence there to prove your case and maybe to protect other employees as well there. Okay, Bogdan, are you still with us?
Absolutely.
He's on the link now. Can you hear me?
Very well.
Thank you. Okay, your next question, please. The draft law by the Ministry of Justice is about any breach of the law should be reported. Do we need guidance on what should be reported?
Yes, this is a very good question, and Madeleine touched the subject a few minutes ago. As you noticed, this is the provision of the law. Should report any breach of the law. But we all know that we need to report the breach of the law according to national legislation. Whistleblowing is more than reporting any breach of the law. It also concerns ethical incidents, for example, a conflict of interest, a corporate gift received breaching the company procedures. So, according to compliance best practice, this is easy supervision to create a so-called business incident privacy incident register, or how is it called in other companies, and in this register it should be clearly defined what is reportable, and this register should be designed in a way to permit the proper training of the reporting, the measures which are taken, and the implementation of the measures. And without a clear definitions of what should be reported will be a total confusion, because we cannot say that any breach of the law should be reported and to not offer guidance on this. And probably will be absolutely essential in the implementation rules, which are basically the bottom of the iceberg and not the peak of the iceberg, which is the law itself, to explain in some details regarding what should be reported, how, and how this is stored in the evidence of the company.
Thank you very much, Bogdan. Thank you. Okay, Denisa, back to you. And we have several questions to go just yet, and we have some questions and answers from people watching as well. So, what are the advantages for companies to swiftly comply with the provisions established by the directive?
Well, if we're taking the US example, we can see that the penalties for not complying immediately to the whistleblowing legislation are way higher than the actual costs of creating a process and an internal methodology and everything that's needed to comply with the directive. So once the companies are complying with the new regulations, they will become a role model within the market. They can continue their operations. They will create a healthy, safe work environment. They will gain the trust of their employees, and they will keep their human resources. Moreover, one thing that is really important is that they will save money. They will increase their costs in a short term, but in the long term, they will avoid the financial losses in case something is happening and that can affect their reputation. And also the reputation is one of the most important things that can be considered by the companies when they're thinking to comply or to swiftly comply to the new regulations.
Yes, reputational risk is very important, because you want to attract the clients and keep clients, and not to make sure that they go to another firm. Indeed, and certainly the risk factor for the companies is big. Ioana, what does the whistleblowing directive mean for companies from a compliance perspective? I know we touched on this a little bit earlier with various comments.
I would just like to add that companies are not supposed to only focus on implementing the procedure mentioned in the draft law. I think it's going to come down to a complete restructuring of everyone's compliance system, because I think this is what's supposed to happen, and this is what's best to happen. And when I say this, I mean not only implement the policy, not only implement the whistleblowing channel that is required by the law, but also think on how you're supposed to train your employees, because as Bogdan mentioned earlier, yes, employees need to know what they are supposed to report, and I think another thing that's missing from the draft law now is the fact that no one tells you or teaches you how you're supposed to assess if a law is breached or not, how you're supposed to assess, because employees are not lawyers. So I think that companies should do a bit more than what the law requires, and means just looking honestly and strategically to the entire compliance system in place, train the employees well, and just try to think ahead what will the reaction of the employees be, and just be one step ahead.
Thank you very much. Madeline, I know time's pressing on, but how to improve the Romanian law to ensure the effectiveness of this whistleblowing directive?
I had a chance to speak to Mr. Burduja just a few moments beforehand. The idea is the following. It took criminal specialists about 10 years to establish what means suspiciune rezonabilă, and I'll say it in Romanian because it's the same. So basically, the same term, we find it again in the law, and this will be a very, very difficult thing to assess. Second of all, and I'm not talking now just to criticize, the idea is to understand and to find this, as I said before, checks and balances system, which to be adapted to the Romanian legislation, because of course we look at our bigger brother, the Americans, and we see this system implied. But please bear in mind there are two different and major differences between us, because over there you have the DOJ or the SEC, which does an investigation, reaches an agreement with the company pays a fine. In Romania you do not have this possibility. In Romania, if you go to a criminal conviction and of course you translate it into money, it's less money, of course it's less millions, it's more in the whereabouts of the thousands, tens of thousands or hundreds of thousands. But on the other hand, you have a criminal conviction and you have all sorts of complementary measures which go along. So from this perspective, it's no longer about reputation. You can be refused by partners having this system of compliance in place. International partners, we have Romanian entities who are requested by their business partners, be it clients or be it some other forms of association, to have these procedures in place because they are required in their turn to be compliant under the FCPA, under the UK Bribery Act, or so on. Second of all, you have to have this in order to qualify for public tenders, because if you have such a conviction, then you can kiss public money goodbye. So all this situation, all these areas, and also you have the media, because you have year after year you have the most preferred employer. the most preferred company in which Romanian employees like to work. So all this creates an environment in which you have to struggle to stay ahead, because competition, just like in any other area, be it commercial or be it from a labor perspective, from a work conditions perspective, is the same. So you have to be compliant, and you have to try to make the legal framework in order to ensure companies be compliant with this, and to think pragmatically, because we've seen also many times pieces of legislation, just like we started before, which at the beginning seem very right, and I'm not criticizing, I also think of possible solution and possible amendments to this law, and I will speak directly to Mike and to Mr. Burduja about this, because it's needed a practical input, because otherwise we just translate legislation from EU directives, we do some kind of norms of application that we copy from left or right, up or down, and then we forget about it. And you have the cases, especially in the public sector. I've had one discussion in the morning with someone who approached us and said, I need advice on how to proceed because I know things. And you have this type of situation in which people have a lot of information, and it's not about the benefit, meaning a reward, as even this is a situation that it's worth discussing in itself. But it's not about the money, it's about the person wanting to make the system better. Understanding that, because if we practice democracy, we have to practice it in all its aspects. And one of this is everyone having or giving their best to ensure the system works properly and ethically. And then you have to create checks and balances to make sure that the whistleblower is protected, but also the company is not harassed by different persons, because you don't necessarily have to be an employee of the company, you can be a former employee, you don't necessarily have to be, you can be a contractor or subcontractor of that company, and so on. You have all this situation which exposed to risk. Of course, you're not going to cover everything in a law, it's absolutely logical, but you have to create the general framework for this to be as ethically and as practically and as pragmatically as possible.
Thank you very much, Madeline. A very comprehensive response there. Bogdan, just moving on to you. The very last question we have for all of our panel here is how the non-retaliation policy may be assured in cases of reporting severe incidents, and we're saying severe incidents.
Mentioned before, because I touched the subject a little bit in my previous intervention, the role of the compliance officer is essential here, because if the compliance officer is well positioned in the company, if it has a correct power to also investigate the compliance incidents and in the same time to assure the correct implementation of the non-retaliation policy and the protection of the whistleblower, things are going well. Otherwise, for example, if we have a decorative compliance officer reporting to a department, to legal, to finance, to HR, there are many situations like this. We cannot speak about investigating a compliance incident or protecting the whistleblower. And the consequence is easy to see, because the people will be absolutely scared and will be reluctant to report any incident. And I saw, for example, I can give you the example of our experience of Ministry of Justice and with the agencies and ministries which are in scope of the National Anti-Corruption Strategy. They have zero reporting in the last 2 or 3 years. Because, for sure, they do not trust in the efficiency of the compliance or ethics officer. They have the position in the organizational chart, but they purely do not believe this position is effective and their protection is assured in case they report an incident.
Thank you very much, Bogdan, for touching on that for us. We've now reached the conclusion of our panel here, and I do have some questions which have come in from people that are watching virtually or in the audience here. One is from Marcel Ionescu Uroya, who's a senior specialist at the World Bank. What models in the EU and beyond can Romania draw on when it comes to whistleblowing regulation? We talked about the US quite a lot, but are there any other systems that could be touched upon, Denisa?
I guess Romania was the first country in EU who adopted actually a whistleblowing law back in 2004. So we're being an example as a country within Europe. So I guess we will implement all that it's established by the directive also in due time. We will take also the US example, but since we're all the EU countries are at the beginning with the whistleblowing process, I think we can learn from each other, but there's no other example within EU in terms of whistleblowing. Only US is way in front of us.
Thank you very much. Most of the other questions have been answered already in various discussions that we had, but very last question, Madeline, if I may ask you, please. We have a gentleman, Gerald Robinson, who's a partner of Hallonen Law, does give an incentive to whistleblowers to report fraud to persons outside of the company conflict with Romanian social norms, customs and values. And also please provide insight on how likely it is that the new whistleblower law will create change within Romania and beyond.
As someone said before, as a former communist state, we have a lot of experience with whistleblowing. Back at the time it was called differently, but that's a different discussion. On the other hand, if you start paying for it, we might be in the same position that we know this happens, but it's a practice of a separate division in our state which handles this type of cases. On the other hand, paying for whistleblowing is not necessarily in itself a bad thing, because there's a certain degree of discomfort, I'll put it in a general term, for the whistleblower, for sure. If it's a grounded case, if it's a clear case, if it's made in good faith as it should be, of course that whistleblower has a lot of problems because of this. On the other hand, there is a principle which in continental law comes from the Romans, which says that you should not be wealthier than you deserve to. I'm trying to make an approximate translation. Basically, who draws the line? It's just like in road traffic accidents. Who draws the line? What this discomfort should be paid with? Okay. If we are discussing, and we were discussing beforehand a few months ago about capping abuse of power, for instance, maybe it would be a nice discussion to have a certain, I don't know, degree of capped bonuses given to those persons. Maybe we can discuss some sort of other incentives that we could give this kind of persons. We should consider that if we want to move away from the 10th degree of bribery, which is considered to be the norm in the public sector, we should not get into the extreme situation where we give 10% to a whistleblower telling us what we already know. Because it's pretty much the same thing. We just move the award from the public official to a private to a private entrepreneur who might find the way to use the law in his or her favor. And this is not something which we want to do. We want to make things better. So if we want to make things better, it should not be about the money, from my perspective at least.
Thank you very much.
Can I add something?
I'm sorry?
Can I add something?
Yes, you can, yes.
Well, as you mentioned, the communist period, I think it's really important for us not to confuse the term of whistleblowing with the term of informant. This is something that we clearly have to to clarify within the Romanian community, because we do have some history regarding the informants, and we do have to make the difference between the two terms. In reality, now, that's a huge problem now with the whistleblowing. The Romanians will perceive it as being a threat or something that is bad, negative, where in reality it's just doing the right thing for yourself, and also for the benefit of the others, of the community, of the company, of all the other persons who are around you. So informant is something that is related to totally different things, and whistleblowing is a process that has to be implemented by companies, but is considered to be healthy.
Thank you very much. Just to wrap up, as they say in England, I just want to say that as I said earlier, Romania has a unique opportunity now to adopt this legislation, and I know it will come in, but it's to make sure that it's the correct legislation, and that, yes, it has to be adapted to Romanian law. One understands that totally. But there's three winners out of this. One, okay, that the four winners. One, the company who has a whistleblowing scheme, will have not any issue now with any other clients. I feel they have a good reputation. People can see that they're transparent and honest, and that they're doing the right thing. And of course, Romania will benefit from this with Romanian businesses, and also businesses from elsewhere. And as we know from Simona, multinational businesses that have it already ingrained into their ethical system. But two, also the state, the Romanian government has a play to gain from this as well. And that from my background with asset recovery at the London Asset Confiscation Enforcement Team, we had the fact that you had a criminal, they have to pay the confiscation order, and not just on paper, but in reality as well. So when they get convicted because of the whistleblowing activities and the information on a conviction at court, then their assets should be seized, the money paid to the state to go through to the relative right, the Romanian Treasury, for example, the NAF for the asset recovery, and other departments. That has to be looked at. Also, the Romanian citizens also benefit from this as well by having an honest and transparent system here. Again, they can see on the news, they can see social media that efforts are being made by the Romanian government, and all of us as colleagues, that everyone gains from this, but in the correct legal agenda and the legal way. And I just hope that, of course, law always is a moving beast. Things change as time progresses, and as case law changes, of course, that changes. But let's see what happens, and I just hope that everything will be in place in December with everyone, and please consider this. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you, Bogdan. Thank you, Bogdan.
Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond.
Good afternoon or good morning, wherever you might be. Welcome to what I believe is the last discussion during our conference today. My name is Mark Worth. I'm speaking to you from Berlin, Germany. I am the director or coordinator of several NGOs that work on whistleblower protection and whistleblower policy and activism, including Whistleblowing International, the Southeast Europe Coalition on Whistleblower Protection, the Center for Whistleblower Rights and Rewards, and a new whistleblower center here in Germany called Whistleblower Herz, which means whistleblower heart. I really want to thank Mike for organizing this great event. It's very exciting. We have some wonderful people to join us here in a moment, and I'm thrilled to be involved with this conference. I have been working on whistleblower cases for 35 years in different capacities, including the last 10 years in Europe, working on whistleblower cases, helping to get whistleblower laws developed and passed, monitoring them, how they work in practice, doing lots of advising and consulting of government officials and the European Union, the European Parliament and Commission, rather, the OECD, the UN, ODC, and many other agencies and organizations, as well as building campaigns for whistleblowers in many, many countries, mainly in Eastern Europe, helping investigate whistleblower cases, publicizing the disclosures, the corruption reported by the whistleblowers, and trying to build capacities among grassroots activists and independent journalists in Europe. So I'm very thrilled to be with you today. And again, thank you, Mike, for the lovely invitation and for putting this whole thing together. It seems like on rather short notice and wrapped it up really nicely. So I'm going to introduce our folks with us today. First is Stephen M. Cohn, who you may have heard from earlier. Stephen is one of the top whistleblower rights attorneys and experts in the world. He is a founding partner of the elite whistleblower rights firm of Cohn, and Colapinto in Washington, D.C., and the founder and current board chair of the National Whistleblower Center, also in Washington. Stephen is the author of 8 books on whistleblower law, including the seminal work, which I have read cover to cover, The New Whistleblower's Handbook. And Stephen has represented dozens and dozens of major whistleblowers over the past 35 years, having many, many successful outcomes, including our next panelist, who I want to introduce, is Bradley Birkenfeld, who you also heard from earlier. Bradley is a former banker and wealth manager at UBS Bank in Switzerland. Around 2007, he became the first international banker to blow the whistle on illegal offshore accounts held in Switzerland by US citizens. For his disclosure, as we all know, he received the largest qui tam whistleblower reward in history. And his disclosures, most importantly, we've talked a lot about rewards today. We're not talking enough about the impacts. And Stephen mentioned this earlier. What Bradley did was result in unprecedented recoveries to the US Treasury in the form of about $800 million paid in penalties by UBS Bank. We don't know how many billions of dollars were recovered in taxes as a result of what Bradley did. Maybe he can update us, but something like $25 billion recovered in evaded taxes that were being evaded because of the operations of UBS Bank, and sanctions against thousands and thousands of tax cheats in the United States and perhaps other countries. And of course, he's the author of Lucifer's Banker, The Untold Story of How I Destroyed Swiss Banking Secrecy. We also have with us a very amazing person, Jane Turner. Jane is a member of the board of directors of the National Whistleblower Center, working with Stephen. As a special agent with the Federal Bureau of Investigation in the late 1990s, she exposed the FBI's failures within its Crimes Against Children program. You can read all about Jane's story online if you want to take a moment to read about what Jane did. Jane was removed from her senior position within the FBI as retaliation, and many years later won the maximum compensation for what happened to her, $1.5 million. The FBI was found to have illegally retaliated against Jane. She is now a writer for Whistleblower Network News, and she writes the very popular weekly column, Whistleblower of the Week. Finally, Giancarlo Spagnolo is a professor of economics at the Stockholm School of Economics and the University of Rome Tor Vergata. Giancarlo is an internationally recognized leader in research on antitrust, public procurement, and the legal tools to fight organized white-collar crime and whistleblower reward schemes. He's one of the leading researchers on rewards, so it's great to have him here with us to dispel a lot of the misconceptions about rewards in our society, and some of which have been expressed today. Giancarlo has published extensively on these subjects in top research journals and has advised many national and international institutions. That was a mouthful, but I wanted to tell you folks who you're listening to, who you're dealing with. This is really a rare opportunity to hear from many of the top experts who have the benefit of being independent. None of the people you're hearing from on this panel have any kind of conflict of interest that might color their viewpoints. They work independently. They have developed their own area of expertise and work. They do not work for companies. They do not work for governments. They are independent people. So what you're going to hear from them is unvarnished truth from their perspective of working for decades, not just on whistleblowing, but having a better world, free from corruption, with honesty and integrity and accountability for all people. I'm going to give a short introduction, then we'll rock and roll. In 2004, as many of you know, Romania passed what I believe was the first whistleblower law in continental Europe, and maybe the third law in the world. It's called the Law on the Protection of Public Officials Complaining About Violations of the Law. It's a short law, it's 4 pages long, but it has a lot of the basic themes that we know about: anti-retaliation, what offenses can be reported, very broad definition of what can be reported, what a whistleblower is, how a person can be protected from retaliation, the fact, even this is very unusual, that a person can go public with the information. You don't have to go internally or to the regulator. This might be the only law in the world that gives a citizen, a person in Romania, the right to make the disclosure directly to the media, to an NGO, on the rooftop, anything they want, as well as reporting internally or to a regulator. And it has the unusual feature that if a whistleblower is disciplined, that the news media and a member of a labor union can be present at that disciplinary hearing. That's extraordinary. And it requires internal mechanisms to be set up. So in terms of 2004, when we only had 3 whistleblower laws in the world that I know of, the US and the UK, it was a pretty darn good law. It generally comprehends the concept of what a whistleblower is, that the person needs protection, and a little bit about how to do that. I've done a lot of research on whistleblower laws and cases, mainly in Eastern Europe. Some numbers I have from, this is a little bit old, but between 2011 and 2015, in that 4 or 5 year period, there were 1,643 reports made under this whistleblower law. This is according to the Anti-Corruption General Directorate of the country of Romania, the Anti-Corruption General Directorate. 1,643 reports were made under this law. But only one of those reports involved somebody being retaliated against at work. And no cases at that time were known to be forwarded to the courts. So this shows that Romania has had 17 years to implement this law properly. I have talked with many people publicly and privately in Romania, in the public sector, who have a lot of confusion and misunderstandings about whistleblowing, perhaps because of some of the reasons that were discussed during the last panel. But if we had 1,600 reports made during a 4 or 5 year period, and only one of them involves somebody being retaliated against, something is not functioning properly in the system, with all due respect to the people in charge of the law. There's a case right now involving a political party that has been accused of making political appointments to water systems, to local water systems, to people who are not qualified to run a water system, but were appointed anyway. The person was disciplined or fired. And I don't know of any cases in Romania where somebody was protected. Maybe it has happened, but I have a lot of contacts in Romania. I don't know of any cases where the system has actually functioned. So Romania had the audacity of hope, to steal a phrase from former President Barack Obama, had the audacity of hope to pass a whistleblower law 17 years ago. And I'd like to ask Stephen, if I could, to start out with Stephen, since he has worked all over the world, has helped write many, many whistleblower laws in the United States, knows these systems backwards and forwards. What, Stephen, do you think Romania can do after having not the best success over the past 17 years, not just to pass a good whistleblower law, which seems we're heading in that direction, but quite simply, how can it work? What sort of approach do the public officials have to take when a case comes in? How can they treat the cases fairly, objectively, with empathy for the citizen, and focus on the protection and the investigation of the report? What would you say, Stephen?
Well, thank you, Mark, for the introduction. The statistics out of Romania are not unique to Romania. Those are systemic to laws that only protect against retaliation. a law that only protects against retaliation is kind of backwards, because you don't obtain protection until you're forced to suffer. And most people don't like to suffer, so most people never blow the whistle. In terms of creating a law where people actually will report crimes, it's very well established. First, you do need a legal framework. Without a legal framework, you have nothing. And the EU directive creates an opportunity for Romania to create a legal framework. And those frameworks are well established. They work. They work transnationally. So you can look at the US Dodd-Frank Act or the tax whistleblower law, false claims. We know precisely what needs to be in a law to make it work. We also know that there are I believe in the 35 years in the United States, there's no evidence of even one whistleblower who filed maliciously ever obtaining a reward. There's all types of protections and procedures. So first you need the law. Second, you need a whistleblower office that can build trust among the people. And that trust, it may take some time to build, but it needs to be carefully thought out. The people need to be trained in very strict protections for whistleblowers, and they must pay the awards without blinking. There's this massive hesitation I've seen, and it's just out. The programs that work understand pay awards, pay that large awards. They send a message to the people. In Bradley Birkenfeld's case, when the IRS gave him $104 million, forget what they gave to Bradley. They sent a message worldwide that the U.S. whistleblower system works, and you should come in and file your cases. It built trust. Get the law, establish a good office, and start paying rewards. It will all work out. Thank you.
You talked about trust, Steve, at the whistleblower office. Are you talking about making it clear that the citizens can trust the office to take care of them properly?
Well, absolutely. First, you need the rules that are ironclad for anonymity and protection. Then you need the people in the office that will follow those rules. So a reputation can be established among employees and the lawyers who would be referring whistleblowers to this program. And that's what you have to build, is trust. I understand the SEC, they do training. In working with some of these investigators from the whistleblower offices, I have been in shock as to the sensitivity, the understanding they have, and their willingness to push things through and make sure whistleblowers are protected and rewarded. They've done a great job, and that easily can be implemented in Romania or any other country.
I want to make a quick note. Thank you, Steve. Following up on a question from the last panel, we do coaching, we do training, and there's a country very near to Romania where we have done that for several years. We helped with the whistleblower law. And quite recently, we had the first successful case of a public employee in this country being protected, being reinstated. We think the person will be compensated for damages. We're not ready to make the announcement yet, but Steve is right on the button, and also the same in countries like Slovenia, and also in Montenegro and Ireland, where you have a whistleblower office, where the people know what they're doing. Even in Bosnia, where the head of the whistleblower office in Bosnia and Herzegovina wrote his master's thesis on whistleblower protection. The laws are starting to work. It might not look pretty or be simple, and these cases are not well known because the media will not write good stories like this, because that's not how the media works. But we personally know of many countries in Europe where the systems are starting to work. 1, 2, 3, 4 cases where protections have been granted. And I've met the whistleblowers who were protected, and they're very grateful. But Steve is right on the button with how the whistleblower office needs to be independent. It needs to have the trust of the citizens. They need to have strict rules and training and the empathy that they're there to serve the citizens. Speaking of citizens, Jane, what you've experienced at the FBI, I want to ask you a question about witnesses. We love witnesses. Somebody sees a house burning down, somebody saw a bank being robbed, somebody sees somebody's luggage being stolen at the airport, somebody getting beaten up on the street, the person calls the police, the person's a hero. We love witnesses. There's not one country on this planet where we don't love witnesses. Whistleblowers are witnesses in the workplace. It's the only thing different about this kind of witness. It's the reason we're here today. We wouldn't need a whistleblower law if these people were not witnesses in the workplace. Why is it that just because you are a witness in a workplace, why are you in special danger, whereas any other kind of witness is not exposed to these kinds of dangers?
Thank you for that question, Mark. And I have to say that besides a FBI whistleblower, I'm also a whistleblower advocate. And 25 years ago, when I blew the whistle in the FBI, to be a whistleblower was not considered a heroic act. It was seen as a David and Goliath battle that could never be won. And you became an outlier, belonging to no tribe. As Plato noted, they deem him their worst enemy who tell them the truth. We were the worst enemy. The director of the FBI said at that time that whistleblowers in the FBI were enemies of the state. Names like snitch and rat were used. I have talked to many, many whistleblowers for the Whistleblower Network News, our online newspaper, and a lot has changed in these last 25 years. Whistleblowers are a lot closer to the hero status these days than the rat status in American culture and in terms of the actual laws protecting them. So what has changed? Whistleblower protection laws and regulations. For example, the Whistleblower Protection Act of 1989, a federal law that protects federal whistleblowers. We have the Office of Special Counsel that investigates federal whistleblower complaints and prohibits personnel practices like reprisal for whistleblowing. We have the Merit Systems Protection Board, which adjudicates whistleblower complaints. And let us not forget the biggest weapon in our quiver for some whistleblowers, the False Claims Act, which is a federal law that imposes liability on persons and companies who defraud governmental programs. This is where you have the QTAM provision, which allows the whistleblower to receive a portion of any recovered damages. As of 2019, over 72% of all FCA actions were initiated by whistleblowers. The government has recovered more than $62 billion. That is with a big B, $1 billion with the False Claims Act between 1987 and 2019. In 2020, more than $2.2 billion was recovered. That is the B number again, $2.2 billion. So to answer your question, Mark, the culture has changed and the laws have changed. Two of the most influential people in the fundamental change for whistleblowers were on this group that you have, Senator Grassley and Stephen Cohn and the law firm Cohn and Colapinto, who had been so instrumental in bringing about legislative, legal, and cultural change. The perception of whistleblowers have changed. But what has not changed is whistleblowers themselves. They still face retaliation and harassment. They lose their jobs, their health, and many times their identity, their social circle, and sometimes their family. Whistleblower stress can be seen in the anxiety and depression they suffer. So I'm glad you asked that question because it is a culture change. And I'll talk a little later about an actual case.
But you
So
were an
thank you, Mark.
employee. Sure. Thank you, Jane. You were an employee. So you were automatically, you were automatically susceptible to all kinds of things because you had managers and directors and a big establishment of top brass people above you. I know this sounds like a simple concept, but as soon as you say the word whistleblower, everybody gets nervous. Everybody gets upset. Everybody starts to worry, like the people during the last panel talking about having to have checks and balances and this kind of thing. Companies worried. Well, we don't have any of those things if you're just a regular witness on the street seeing a crime go on. You just go back home and nothing happens to you. So don't you think it's a shame in our world that we need to have these very complicated legal systems and rules and hotlines and lawyers only because you're an employee? What does that say about where we are, do you think?
Well, I think that's a really good question. And I think that, you know, the whistleblower 25 years ago, and I go back to them because we have had so much that has changed. Whistleblower was a concept that, take for example, Francesco Serpico of the New York Police Department fame detested. And he came up with an alternative known as lamplighter, which never really caught on because the concept of blowing the whistle is a strong one. And Sharon Watkins of Enron fame, the company that was involved in multi-million fraud, she also eschewed the whistleblower name. She did not like that. But in these last 25 years, it has changed because the culture has changed. And so these whistleblowers now embrace that label because our culture now sees them as heroes. They consider Serpico a hero. Sharon Watkins is a hero. And this is what Hungary needs to address, is their heroes. They need these kind of heroes who speak truth to power. And people who speak truth to power, they scare the employees. They scare the FBI. They scare institutions, federal institutions. They scare business because just that's the fact. They're speaking truth to power.
Stephen often makes the point that you need whistleblowers because they're inside the organization. They have the firsthand knowledge, the firsthand evidence of the wrongdoing. That's obviously the case with what happened to you, Jane, what you reported. The fact that the employees are the ones who have the documents in their hands. I got a call yesterday from an employee of an ex-employee of a very, very large German company, and I'm waiting on getting these documents from the person. They have the information right on the inside. Maybe the whole story, certainly most of the story. Bradley had it right in his hand, names, amounts, everything. So I can see how that might make a whistleblower, make people nervous. And I suppose that's why we need these laws, because they're susceptible to the most kind of retaliation, Jane.
Yes. And, you know, I heard somebody speak earlier about whistleblowers being informants. As an FBI agent, I ran informants in the FBI. And there's a huge difference between informants, which I think connotates negative things in Hungary, and whistleblowers. An informant is a criminal. A whistleblower is a patriot, and they're a hero. And you have to address it that way. Your whistleblowers are heroes, and the United States needs heroes, and Hungary needs heroes.
Thanks, Jane. Giancarlo, you spend a lot of your time lately researching whistleblower rewards. I know we've talked about that a lot today. I've listened to part of those discussions during the day. Lots of misunderstandings, lots of impressions about it. Why don't you tell us, Giancarlo, about what if you could briefly, what research are you working on? what is available? I know a lot of new stuff is coming out in the last year or so. And what are your conclusions and your observations based on what you have empirically researched yourself?
Okay, thanks for organizing all this. Even in this conference, I heard people repeating misinformation that was spread by sometimes regulators. Think about the note by the Bank of England, which is full of false claims. And how this influenced actually the lack of a specific section on rewards in the European Directive, because they were misled by a fundamentally false report written by the UK regulator, which are very close to the city and the banking system, which is becoming the biggest money laundering center in Europe. If you look at the last thing we wrote, we saw that England is the biggest infringer in terms of corporate fraud in Europe. So a lot of misinformation. Let me tell you about independent research. I just talked about independent research by academics who are not funded by anybody. Because you need data, this research is coming out only now, and is only on US, because US has the best data and has the longest experience. There is very strong evidence that this program, as administered in the US, and this is important, are super effective. They are super effective in terms of detecting misdeeds by corporation, fraud, from financial fraud, corruption, and so on. And they are super effective even in deterring. So there is new evidence. There were 2 papers by young PhD on the job market this year showing a prevention effect. So these programs are reducing future crime. This is an effect which is very different to measure. We don't have the strong evidence, for example, that longer years of prison have any deterrence effect on crime. There's been 30 years of research. It's very difficult to find deterrence effects, so prevention of future crime. In this case, we have strong evidence that this whistleblowers program deters and prevents future crime. This is a very big thing in academia. People still say, oh, but we're going to be flooded by new claims, false claim. Well, sorry, bullshit. We have the evidence. There was no problem of false claims, also because they make a consequence on false claims, at least in the US. We calculated in some of these studies the return on investment. So how much you get back as the government or as the citizen if you invest $1 in whistleblower rewards program, and the range goes from 30 to 50. So for every dollar invested in a whistleblower reward system, you get 50 back. This is what the number of international independent researchers came out. So lots of detection, a lot of deterrence, and a huge cost efficiency in terms of law enforcement. Now, this is not a very novel thing. If you think about how Italy and US collaborated in breaking down Sicilian mafia in the 80s, in the 90s, they used kind of a whistleblower protection. They protected whistleblowers. In that case, actually, it was not whistleblower. In that case, it was accomplice witness. So we should not, as Jane said, whistleblowers are heroes. These guys were former mafia guys who actually decided to report, but the government offered them protection, new identities, and a way to survive, and protection for the family. And that was the unique single tool that managed to break down the Sicilian mafia. So we have a lot of evidence that these things work, but you have to do it actually well. So the only one concern in Europe is that Europe has much lower fines, and it's much less aggressive in terms of recovery damages. So to get support for this, first of all, we need big, rough rewards to make sure that whistleblowers are really protected, because most of the protection is partial. There will be always forms of retaliation from which they will never be protected. So the reward should be seen also as compensating for this lack of protection. And but if you want to fund this from fines and from seizure from other from the criminals, you need to also be tough with fines and aggressive in terms of recovering the asset, which is not often the case in many European countries. That's something that should be addressed well. And I would stop here. I mean, I have plenty of things I can talk about later, but the evidence, is this is the most efficient legal tool ever studied in law and economics. Full stop.
Isn't it the case, Giancarlo, that the only major result, the only major change that has occurred when you introduce rewards is that the number of reports goes up, and perhaps the quality of the reports goes up, and even if it does result in some false reports being made, that those are just filtered out naturally anyway. And as Steve said earlier, there's never been a case of a malicious whistleblower receiving a reward. Isn't it the case that the only result is that the number of reports go up, which we've seen in the United States and the Republic of Korea, South Korea, and there have been no measurable negative results from the introduction and expansion of whistleblower reward programs?
Absolutely, yes. Absolutely. This is the only thing that the data says. All these words that are spread by scared regulators, that there will be malicious reporting, and there will be false reporting by the employees, and so on and so forth. This has been said repeatedly by the Alliance of the German industry during the Germans are terribly scared because, think about the German history. They got the Siemens scandal, they got the Volkswagen Dieselgate, they got the Wirecard. Not a single whistleblowers came out. Of course you don't. If you lose the career, even if you're a hero, you may be scared of that. So yes, it's exactly what you say. All these voices and concerns spread even by the Bank of England are baseless. If you look at the number and the research, it's the opposite. They're just scared, or maybe they are corrupt, but the British banks are doing money laundering. I don't know why they still spread this fake news at that level.
Well, I received a call once from a person who said, "Oh, Mr. Worth, I have a case and my reward is going to be bigger than Mr. Birkenfeld's. Let's work together and make this happen." And the person had there was just nothing there. It was not a real case. So I believe in free speech. I think anyone should be able to say anything they want to say as long as it's not threatening or harmful to someone. It didn't bother me at all to receive this, to talk to this person. And maybe it took 10 minutes of my time or 20 minutes, doesn't matter. So I might be on the radical side of things, but I'm not afraid of receiving false reports.
But with the amount,
because I look at them and then I just set them aside as being not a real case.
But the amount of recovery is so large that paying some more people to screen a few more or many more reports is negligible compared to the gains. So yes, you have to hire some people, but as we said, the return on investment is 50%. Where is an investment that gives you 50 times? Sorry, not 50. Tell me one investment, public investment, that gives you a rate of return. That you invest $1, you get 50 in return. So investing $1 into these laws and to hiring the people to screen those reports, and you get 50 against. That's what the data says.
Yeah, it's amazing. Thanks, Giancarlo. Bradley, just picking up on what Giancarlo said and listening into the previous panel, the fears from people who work in the private sector and the lawyers who represent them. To be quite honest, these whistleblower laws are not there as in such a way that the companies are the main beneficiary. The companies are not the main beneficiary of these laws, as far as I can see. The main beneficiary is society and citizens who make these reports. So you worked for private companies. You're a whistleblower. What are your thoughts about that? About a reality check? And I understand, but if you're a company and you're afraid, well, you're only going to be afraid if you're doing something illegal, just like anybody else. If you're speeding, you're going to get a ticket. If you're not speeding, there's no reason to be afraid of getting pulled over. So what kind of common sense a reality check, Bradley, could you say to companies who are worried about whistleblower laws, and including from the perspective of even before a whistleblower law, people can make reports without a law, and a whistleblower law probably will not lead to a huge cavalcade of new reports in Romania.
Well, thank you, Mark, for that question. I'd like to comment really briefly on each person before me who spoke, Stephen, Jane, and Giancarlo. I think it's very important to understand, if you don't break the law, you don't need whistleblowers. It's that simple. But to touch upon what Steve had said, no malicious actions were filed by a whistleblower. I'll take it a step further. On the form that you fill in, the forms I filled in, the Form 211s, they're signed under the pains and penalties of perjury. So the very fact that that is there to prevent that kind of nonsense. So that's very important to understand. With respect to what Jane was saying as well, I think it's important working at the FBI. When we had the terrorist attack of 9/11, they offered $25 million cash for a reward on Osama bin Laden. So what in fact are you doing? You're paying money for information. And it yields benefits, as we all agree. Those benefits are incredible. They bring back money to the Treasury or to the taxpayer and so forth. And to touch upon what Giancarlo said about deterrence, and he's absolutely correct as well. Deterrence is a big part of this, not just incentivizing the whistleblower, but the deterrent factor. I guarantee you, if you put into the law that the CEO of the bank or the institution that was doing the illegal work, and he has to go to jail for at least 1 year, you will start to see all of this waste, fraud, and corruption come to an abrupt halt. So maybe you have to start holding the CEOs accountable and not just letting them write checks. You rob a bank for 10 million, you give back 8 and keep 2, and nothing happens. That's a great system. That's exactly what UBS was doing and got away with. But I held them accountable. But those points I've just raised on each of the other panelists, what they've said, I think is important, because what you begin to realize is that in a society of whistleblowers, whatever you call them, the fact of the matter is they're going out of their way to help, and they're an extension of law enforcement. Law enforcement doesn't have the budget. It certainly doesn't have all the staff. Maybe they're corrupt themselves. So a whistleblower is going to give you the entire treasure map, and that's what's very important here. So I think what we have here is a variety of factors that have to be addressed, from the pains and penalties of perjury signing forms, certainly the deterrent factor, which is very important. Hold the CEO accountable. See how that goes. And then it sends a very powerful message. And the other thing I would also add would be, why don't these whistleblowing offices hire actual whistleblowers? Let them come in and work at the SEC, the IRS, the CFTC, and build an elite team within that group of some whistleblowers that have actually been through the process. I think that would be very helpful as well.
Thanks, Bradley. We wouldn't need as you referred to, we wouldn't need a whistleblower law if there was no retaliation. We wouldn't need any of this stuff. And I don't want to sound like I'm anti-private sector. I love the private sector. It's the main driver of the economy. We need to support the private sector in any reasonable way. But how would you respond to what some of the people said during the last discussion, Bradley, about their worries and concerns? Isn't it a little bit disingenuous for them for a private sector, somebody who works for a private company, to be overly, isn't it collectively the behavior of the private sector is one of the main reasons that we have new criminal laws on private sector crime. Whistleblowing also happens in the public sector, as we all know. But the private sector itself is one of the main reasons we have these frameworks. But then for the private sector to not see that, do you think they're in denial about why we have a whistleblower law in the first place?
Well, they're not in denial, I would say. They certainly see this is a tsunami that's going to hold them accountable, and I think that's exactly what they need. Again, if you don't break the law, you don't need whistleblowers. So it's very simple. The fact here is that the private sector, because there is so much money in a lot of these industries, and we'll just name a few, let's say finance sector, pharmaceutical sector, the military, construction, and I think what you have is this sort of environment in which it's okay to have a kickback, or it's okay to increase the value of a contract to make more money, or what have you, because your friend's going to get you the contract, or whatever it might be, the transgression and nefarious acts. So I think the point here is that if you're not breaking the law, you shouldn't be worried about a whistleblower. But you don't like the whistleblowers because you are breaking the law. It's that simple. So right. the whistleblowing laws have to be increased. I would hold the CEOs accountable. Put the CEO in jail for a year. I guarantee you're going to see this come to an end real fast.
The idea of these compliance offices, and I've researched these for many years. I got a call recently from somebody who was basically entrapped by the compliance department. The person went to Dow, I have this information about corruption. Oh, yes, please give us all the documents. Tell us what you know. And of course, the person was dismissed, and terrible things happened. These firewalls that supposedly exist within companies about compliance and audit committees, is it reasonable to expect, and these firewalls, as far as I know, are not, maybe they are legally enforceable in some countries, I don't know, I'm not, but is it reasonable to expect, Bradley, to have real firewalls? Can we expect a compliance office that reports to the CEO in one way or another to be independent, to maintain confidentiality, to maintain anonymity, and actually protect the person? How is that, can that be reasonably expected in today's world?
In my opinion, no. And I'm a perfect example of that. I went to my legal, as a director of UBS in Geneva, Switzerland, I went to my legal department and my compliance department, two separate departments, and I put it in writing, not just 1 month, 2 months, but 3 months, never got an answer. I was then I forced myself to resign because my own compliance and legal departments wouldn't answer me. So that in of itself is the problem. You should, as Steve Cohn said before, you shouldn't have to report to the people who are breaking the law. Geez, let's tell them our game plan before we go into a football match against the competition. I mean, that's exactly what you're doing here. So you should be allowed to go to regulators. You should be allowed to go to law enforcement. You should be allowed to go to the media, as I did. I used the media as my back door because I couldn't trust the bank, number one, but I certainly couldn't trust some of the law enforcement I dealt with in the United States. So I always had a back door through the media. So really what we have here is a situation where going internally doesn't work. And even after I resigned, going to legal and compliance for 3 straight times in writing, I then went, after resigning, I went to the board of directors of the bank and complained because I was still on the payroll for 6 months and invoked my whistleblowing rights. And then they called an investigation and covered that up, which then brought me to the United States to complain about this and bring it to my own government. So I'm exhibit A of why it does not work internally, because what you're doing is you're going to the people who knowingly were breaking the law and you're going to tell them what you're doing. Absolutely doesn't work, and I'm never for it.
Well, I'm concerned about the internal reporting industry, if you want to call it that. I'm glad, I'm thrilled that the directive does not require the employee or to go internal first. They have a complete right, a full right to go to the police, go to their boss, go to the regulator. They can do that without any conditions. This was a major victory by the National Whistleblower Center, by you, Bradley, other people who campaigned for that. Huge, huge. But I'm still concerned that the internal reporting channels that are being set up by these large companies and medium-sized companies will create an environment where the employee will develop a misplaced trust in the internal channels, think that's the way to go, and then we know what could happen. Bradley is Exhibit A for many things that need to be in a whistleblower law and many things that should not be in a whistleblower law. Bradley, I'm sorry.
Sorry, one other thing, Mark. I just want to add this one piece. Just recently, I was in Paris at the UBS appeal for their tax evasion and money laundering case. That number will probably be reduced because, as Giancarlo rightly pointed out, the fines are very low in Europe, and that's wrong. They should be actually increased, not decreased. That's one thing. The second thing is that the biggest problem here is then once the bank, in my instance with UBS, when they got fined, there's to fight the case, they hire a lot of lawyers. So the legal costs are astronomical, number one. Number two, the fine is then passed on to the Swiss taxpayers because they write it off. So the shareholders pay the legal fees, and they get hit with a big fine, which they pass on to the Swiss taxpayers. Two groups of people who had nothing to do with the crime whatsoever. And the bank just writes a check and walks away. So what I did, and it's on my website if you'd like to check it out, I wrote a one-page letter, op-ed if you will, and I put it in the Zurich newspaper the day before the annual meeting on April 7th of this month. And that letter essentially says, why should the Swiss taxpayers and the UBS shareholders, the UBS clients, and the UBS employees have to tolerate this? This is wrong. And you got to fix it. And I put a full-page ad, and boy, I'll tell you, it was like a tsunami. So I sort of like the confrontation, of course, but I think it's important to call them out on it. And this is wrong. And they still haven't learned their lesson. That's the real problem here. And I think Steve Cohn can comment more on this, is that not just the $780 million against UBS and the other fines against the banks, 100 Swiss banks came in and paid fines and penalties. 100 Swiss banks. Over 100,000 Americans came in and became tax compliant. That means the money left foreign banks, came to American banks, paid the fine and penalties, and the money gets invested and taxed through perpetuity. I rest my case. The numbers are astronomical.
Well, I want to wrap up with Bradley, and then we go back to Steve about how we use the media. Bradley is an expert. He's written a terrific book with a sequel. He has incredible media skills. He's traveled the world. The book has been translated into many languages. Bradley has the financial resources, if I may say, to do a lot of this work, to support his traveling, whatever staff he might have to promote his book. He is able to move on with his life and not have to look for another job because he has some financial resources to become an activist and to remain an activist. Bradley is like 0.0001% of a whistleblower. None of the other people, and he has great media skills. He's a articulate, well-spoken, and funny person who is good on television. He's good on interviews. He knows how to do this. Very few people know how to do that. If it wasn't for Bradley's media skills and his resources, these further prosecutions and enforcement actions against the bank might not have happened. And I don't see him stopping anytime soon. Another reason we need a strong whistleblower law is to compensate for the fact to be a partner with the whistleblower who does not have Bradley's skills, does not have his financial resources. So Bradley is devoting his life right now to keeping this going. And not many people can do that. Very, very few people can do that. So, Stephen, you wanted to follow up on some things that were said. I know that Bradley has addressed rewards and Giancarlo, but you want to make some specific points about rewards and some of the misconceptions or even incomplete information.
Sure, and thank you, Mark. I just want to say this. The main beneficiary of whistleblower reward laws are corporations, period. And a corporation that does not pay bribes to get business is at a radical competitive disadvantage to a corrupt outfit. A company that doesn't violate the law to get government tenders and contracts, an honest company, might go out of business because their competitor pays the bribes and does all the unethical activity. Without a strong whistleblower law, and we know what that means. It means rewards, confidentiality, anti-retaliation. Honest companies are not only at a disadvantage, they may be driven from the market itself. And this was recognized in the United States. We had a massive debate within the U.S. Securities and Exchange Commission. And the SEC is an important group to think about because this is Main Street, Wall Street. These are not radicals. These are not whistleblower advocates. And in 2020, all 5 commissioners, 3 Republicans appointed by President Trump, 2 Democrats, but all Main Street capitalists, essentially, came to the conclusion that the Dodd-Frank Act was a fantastic law, that it was working remarkably well. And guess what? It was the only hope that honest companies can compete. So if you want effective anti-corruption, you have to give the honest corporation a chance. If you don't, the crooks will always dominate and your politicians will be on the take. It's as simple as that. All of the issues raised by other speakers, I made big notes on it. I could do a whole lecture. I think I'll write an article about it. Every single one of them can be refuted. But what cannot be refuted is how can a company that doesn't pay the bribe for the contract and therefore doesn't get the contract, how can they ever compete against a crook? Answer that one. Thanks. Thank you.
Yes, Steve, I think that I'm very excited that people like Giancarlo and his colleague Theo in Sweden are doing this research on rewards. We now have 16 countries in the world, including 5 in Europe, that have some kind of reward program or policy in place. This is up from 1 as of 1986. The UK, Canada, other countries are, the first reward in Slovakia was issued recently. It's a long conversation. There's a lot, as Stephen said, there's a lot to refute, a lot of misapprehensions and we don't want to focus entirely on rewards, but we cannot ignore the data, the impacts, the endorsements by the SEC, of all people, comments from Bradley about it. I don't think the fact that a few people have made a little bit of money earned a little bit of money in exchange for suffering should dissuade a country from passing a reward program. I think if it works, it should be tried. We have to keep, the old expression, you have to keep up with the criminals. As soon as you do something, the criminal gets smarter. As soon as you do something, the criminal gets smarter. We have to have every tool in our toolbox to expose the corruption, which is robbing people, regular citizens of money and services and trust in their country, and it's getting to the tipping point. A lot of the unrest in the world is because of lack of trust in people's governments, local, regional, national. It's hard to measure. But a lot of the, you talk to individual people around the world, a lot of what they're anxious about is this. So this whistleblower law, maybe it's not the most important thing for Romania to pass in the next 8 months, or the other EU countries to pass in the next 8 months. But the results will be really, really strong, very, very effective if done right. I want to go around the table, and I know we have some very important people listening right now in the public, very important public officials listening to us right now. I'd like to have each person give one short message to the people listening in Romania about the importance of doing this right. Jane.
Thank you, Mark. Like the majority of whistleblowers, I suffer from post-traumatic stress syndrome, PTSD. That's one of the scars that I carry. And I offer my apology for misnaming Romania. And I want you to know, Romania, that if you treat a whistleblower like a criminal, you will have no whistleblowers. If you have no whistleblowers, you have no one to take on the heroic act of revealing corruption, malfeasance, and criminal activity. You have no one to bring attention to the wholesale looting of your treasury, your goods, your people. You have no moral compass to show you the way. You have no heroes to show your children. Thank you.
Thank you, Jane, very much. I would encourage everyone to go to Whistleblower Network News. Jane Turner writes the Whistleblower of the Week column, often with videos and podcasts. It's tremendous, and thank you, Jane, for being with us. Giancarlo, some final words for the public officials listening to us right now.
Yes, often people that don't like the idea of these whistleblower rewards, which, remember, they can be seen as compensation by impossibility to protect fully a whistleblower. They will tell you, no, but this is Europe, we have a different culture. Now, first, culture can be changed, but even if you don't change culture, we imported another similar program very effectively from the US, the leniency programs in antitrust. We imported from the US with a very different culture. We adapted it to our legislation, and they are now very effective at national and at the European level. So this story that, there is a cultural difference, we cannot do like the US, is nonsense. It's because they don't want this. Of course, a lot of people are afraid because a lot of companies may not be that innocent on some things. So don't trust them. Culture is not a problem. We have imported antitrust law. We have imported leniency program. We can import whistleblower rewards. So, but we have to do it well, because anything well in the US they did it well. You can always spoil an instrument if you do it poorly. So, ask the advice of the expert when you implement it. That's very important.
Thank you, Giancarlo. Thank you for your research. Your very important research, very credible research on rewards, and we will be spending the next months and years publicizing what you're doing. So thank you again. Bradley, final word for the public officials listening right now.
When my grandfather is from Romania, and I find Romania very close to my heart, hence why I had my book published in the local language, and I lecture there quite often. All over the country, in Cluj, Iași, Bucharest, and so forth. But I would say this, in my lectures in Romania, I said it very simply. I would say it to adults who have children. Do you ask your children to cheat on their exams at school? And they say no. Do you ask your children to steal candy from the local store? And they said no. And I said, do you have your children punch the other players on the soccer field or what have you? And they said no. And I said, why? It's because you live in a civilized society and you want to raise your children properly. Now, if you're going to tell your children not to do those things, why, as adults, are you doing them? Lying, cheating, waste, fraud, and corruption. Stop it. Have a reality check to recognize the fact we need a better society. And whistleblowers are needed in Romania because silence is complicity.
Thank you, Bradley, very much. And we all want to congratulate you on your continued work, keeping pressure on the regulators and the authorities to fully investigate all the crimes that may have been committed by the banks in Switzerland. Thank you, Bradley, for being with us today. So, Stephen, for the public officials listening in Romania, what message would you give to them in closing today?
Sure. So first I want to say that I understand Romania is looking at the directive as an opportunity to implement effective whistleblower laws. So I really take my hat off to Romania, and as it can be a model for other countries. I want to say that the record reflects that whistleblowing works. It works to detect frauds and corruption, and it works to hold the wrongdoer accountable. And I look forward to working with officials and others in Romania and in Europe to go through the details of specifically what has to be in an effective whistleblower law to accomplish the goals we all share and prevent some of the abuses that some have mentioned, but all can be mitigated and stopped. So thank you very much for the conference. Mark, thank you for your kind words, and thank you for all the participants. Thank you.
Thank you, Stephen. And I want to say that it's an honor to be working with Stephen and the National Whistleblower Center and the Cohn Colapinto Law Firm on our effort here in Europe with Whistleblowing International to provide the top information and resources to all the EU countries to make sure, like Stephen said, that the laws are good. There is one country in Europe that I won't name that has one word in its whistleblower law that is creating all kinds of problems, that is working to help people, to result in people losing their cases. One word that literally has been a poison pill for whistleblowers in this European country. We're trying to get that fixed. This is what we're talking about. People like Stephen Cohn, 35 years experience on writing whistleblower laws all over the world. We do that here. We've helped write many laws. The amount of care has to be extremely high to make sure that there are no poison pills, no dangerous loopholes, no language that can result in people losing their cases or not being treated objectively and fairly. And you'd be very surprised. I know we have lawyers listening at how one or two words or a missing comma can result in the law not fulfilling what it's meant to do. So we are at your disposal. We are thrilled to review any draft law that's being put forth, to provide comments based on the best practices around the world. And I would really like to thank everybody for putting this event together, Mike and everybody else. I want to thank my wonderful friends for joining us on this very important panel of independent experts on the issue of whistleblower protection. We congratulate Romania for its public work on getting this law passed. We have 8 more months to get it passed. There's plenty of time to make sure it's a good law. I wish everybody listening today a wonderful afternoon, and we hope to see you again in the future. Thank you very much.
Thank you.
Thank you.
Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond. Has this moment changed customer expectations forever? How can you transform at speed to build value that lasts? Are you reframing your future? Or is the future reframing you? In this time of change, find out how we can help you uncover opportunities now, next, and beyond.